the technology this side.
No, that's fine. I hope we're all ready to start now. Are we all ready to start now?
Yes, my lord.
Yes. Can I start with you, Mr. Hofu? Can you introduce your team, please?
Thank you, my lord. My lord, I appear for the applicant in this matter, together with
Yes.
Thank you. My lord, I'm just checking if your lordship got our heads.
Yes, I've got them at
Yes.
about 11. Yes.
I know. Thank you.
Okay. Mr. Twaito.
Thank you, my lord. I appear on behalf of the chairperson of the commission, Justice Zondo, and the secretary of the commission, Professor Mutala. I appear together with Ms. Musala, rather, with Ms. Muvangwa.
Yes, thank you. Mr. Duplessis.
Thank you, my lord. Together with Mr. Kitsudis and Ms. Tobela Mkulisi, I appear on behalf of the seventh respondent, the Helen Suzman Foundation.
Thank you. Can you then start, Mr. Mpofu? The floor is yours.
Thank you very much, my lord. I can't hear your lordship properly, but maybe the problem is on our side, but I could hear perfectly. Your lordship is saying that I can start.
I can say you can start, yes.
Thank you very much. My lords, we are here for a matter that, in our respectful submission, my lord, should have been a matter that is that's going to take your lordship not more than a few minutes, because in our respectful submission, it's a matter that is in effect unopposed, and I will explain why we make that bold submission, my lord.
Yes.
My lord, you know, one of the remarks that were made, if I may borrow from the main, or rather the minority judgment that brings us all here, in the matter that where the order in question was granted, I see that we attached the wrong document. So I'm hoping your lordship has got the actual document.
Yes, I have the document, yes.
The actual judgment. Thank you, my lord. It's now, I see it's now even available publicly. I will start, my lord, by reading out at paragraph 143 of the minority judgment. Just to put in perspective, they say in law, context is everything.
Yeah.
And at paragraph 143, my lord, the judgment judges Teron J and Jafta J say the following about the main judgment.
Yes.
In my view, it is unconstitutional. In other words, they call that judgment unconstitutional to the extent that it violates sections 12 to 143, my lord.
Yes, I have that. That's fine.
Okay, thank you, my lord. In my view, it is unconstitutional to the extent that it violates sections 12 and 35(3) of the Constitution to order punitive committal for civil contempt in motion proceedings, where no remedial or coercive relief is granted.
Yes.
The main judgment, again and again, answers this concern with recourse to the exceptional facts of this case and the conduct of Mr. Zuma. In doing so, it fails or refuses to see the woods for the trees, with the result that in seeking to justify a punitive order which satisfies an understandable desire to address Mr. Zuma's scandalous disrespect for this court, it trammels over the constitutional rights of alleged contemnors, including Mr. Zuma. And I'm deliberately starting with that, my Lord, because it will be a theme of mine in this address, that we should really take heed of that advice to see the woods for the trees. Now, what have we got here, my Lord? If we take away all the legalese and the terminology that might confuse the public, what we really have here, my Lord, is nothing other than an interdict before your Lordship.
Yes.
Pendente lite, and I'll come back to that. That's crucial. Effectively, to interdict or suspend the execution of a warrant of arrest. And I'm using that term loosely, deliberately, because as I say, if you take away all the peculiarities of this case, that is what we're dealing with. A warrant of arrest and committal. Arrest by the police and committal by the Minister of Correctional Services, effectively. So, as lawyers, we always talk about substance over form. So in substance, that really is what is in front of your Lordship. Should, pending the litigation that will take place in the...
Let me just try and understand you. What
Yes.
is before me is, because the two things here, there is an order and there's an implementation of the order, the source and the implementation of the order. What you're seeking to interdict is the implementation of the order.
Absolutely.
But the difficulty is without interdicting the order itself. You understand?
No, my Lord. It's
Yes.
the execution.
Yes, that's what I'm
which is
trying
the
to
same
say.
thing. Yes.
Yes, yeah, that's what I'm trying to say. That's why I'm trying to understand you. And yeah.
No, your Lordship, yes, we're on the same page, my Lord. Yes, what we're interdicting is the execution of the warrant.
Of the warrant, yes.
Yes, yes. To put it simplistically, your Lordship is quite correct. And that's an important question that your Lordship is asking, because remember, what is the nature of the proceedings before your Lordship? And that, my Lord, will address two things, or will kill two birds with one stone. It will deal with the broad nature of the proceedings that we have brought, but it will also address the red herring submission on jurisdiction, which I will deal with.
I think the issue of jurisdiction is actually central to this case.
Yeah.
I think, yeah.
Well,
I think that's the main issue, really.
Yes, my Lord. Well, I'm glad. If that is the main issue, then, my Lord, we're going to be we won't be very long here. Because that issue, as I say, is a red herring. And its examination, my Lord, starts at what I call the nature of the proceedings. But before I deal with it, my Lord, if your Lordship characterizes it as a main issue, then I need to preface it with all the other preliminary issues.
Yes.
For context, as I said, context is everything. So what we have here, my Lord, is, as I call it, a warrant of arrest for the former head of state, who will be 80 years next birthday, who is not a flight risk on anybody's version, and who, for all intents and purposes, actually is in the in the care and security of the state or of the police or security agencies. Now, I'm going to talk very briefly. Your Lordship, I know you didn't have time to go through our heads, but from the replying affidavit, Your Lordship would have seen that we flagged out an issue of locus standi.
Yes.
For lack of a better word, what we seek to communicate there, my lord, is what we've called the bizarre situation that we find ourselves in. Namely that the principal parties that we have cited in this application, for good reason, namely the police minister, the national commissioner, and the minister of correctional services, and even the president of the country, have elected not to oppose this matter. In the case of the National Commissioner of Police and the Minister and the President, they filed a notice to abide. The importance of that, my lord, will be clear when we examine the nature of the order itself. So essentially, we have three parties who are before your lordship. And we will argue, my lord, that these parties have no business even being before your lordship, let alone to oppose this application. The first party, or the first two, are related. It is the Commission of Inquiry and its chairperson, the Acting Chief Justice or Deputy Chief Justice Zondo. They have elected to oppose the application for the execution of what I call the arrest warrant. Then we have, as if that is not enough, the Helen Suzman Foundation, which really has been cited here simply because it was an amicus in the main proceedings. And that is because Rule 42, as your lordship knows very well, says that all interested parties must be cited. But actually, it's a party that has no business really in this proceedings. And we will show your lordship that neither does the commission or the acting chief justice. Why do I say so, my lord? If you look at the notice of motion, the heading of these proceedings, your lordship will see that we deliberately cited the Minister of Police as the first respondent, National Commissioner second respondent, Minister of Justice is third respondent, and then Minister of Justice and Correctional Services, yes, the third respondent, and only then do we put what we regard as the peripheral parties in this particular application, which is the Commission, Judge Zondo, and the President. And then lastly, we put the HSF. Contrast that, my lord, with the heading in the Constitutional Court proceedings. Which your lordship will find
yes.
You've got them, my lord, yes. Now, your lordship will see that in that particular application, it is the other way around. The first respondent there is the commission, rightfully so. And then it's the Deputy Chief Justice. And then it's the ministers and so on. And there's a significant reason why that is so, my lord. That is because in the Constitutional Court matter, clearly the Commission is the primary party, because that was the party that, after all, went to court. But here, in this application, the real parties before your Lordship are the parties that have been assigned the task of executing this particular order. And my Lord, it's very significant, we say, that those parties, and particularly the police, have indicated, my Lord, as your Lordship will see that in the letter that is annexed at page 624 as R1 to the replying affidavit. That is the letter written by the state attorney yesterday and circulated to all the parties.
Yes, assuming in your favor that there was no opposition at all in this matter, can I make an order as a lower court nullifying the execution of the Constitutional Court order?
Yes, I'm coming to that, my Lord. Well, I was still busy with explaining to your Lordship that is.
I hope we'll come back to it. Yes, that's
no. I'm going to it right now, my Lord. I'm just interposing this remark that in my respectful submission, your Lordship's assumption that the matter was not opposed is not an assumption. It's actually a fact. That's the submission.
Yes, and I know it is opposed by at least the fourth and fifth and Helen Suzman Foundation, the 7th respondent. I know that.
Yes.
Assuming that's why I say if I take them away from the equation.
Yes.
Yes.
No, my Lord, I'm with you. No.
Yes.
We're together, my Lord. Yeah. Okay. I'm saying that your Lordship is quite correct. Even in the unopposed motion court,
yes,
your Lordship would still be entitled to ask the questions to satisfy your Lordship that your Lordship is not straying over. No, I appreciate that, my Lord. So if I can just then finish that thought, my Lord.
Yes,
yes. That in our respectful submission, these parties have no business as far as the execution of the order is concerned, and they really are here as uninvited busybodies, which really should not. It's actually inappropriate for both of them to be before your Lordship in a way, because in the case of the Commission's role really should have effectively ended as far as the execution is concerned when it obtained its order. And obviously, once the rescission was asked for, then as I said, primarily its interest was reignited, but not in the context of what is before your Lordship. And your Lordship knows the background of this matter, that it really comes from what one might call some kind of acrimony, rightly or wrongly, between the applicant, former President Zuma, and the Commission and its chairperson. The Lordship knows the background. There are recusal applications, there's a review application pending before the courts, and so on. So one would have thought that it would be, to put it mildly, impolitic or ill-advised for the Commission to enter this particular fray, because they've got their order. And as to whether the applicant, former President Zuma, will be arrested this week or next week or after the hearing of the Constitutional Court and so on, really it should be no skin off their nose. because, as I say, they've got their order. Unless if there was some fear that he might fly away or that kind of thing, or he might interfere with their rights in one way or another. So opposition that is based purely on vindictiveness and the desire to see Mr. Zuma or former President Zuma punished today or tomorrow is, as I say, at the very least, inappropriate in the present circumstances, given the history of this matter. What is really the interest that these parties are trying to protect? I've been asking myself, and one cannot find any interest that they would like to protect. If the police were opposing, one would say that the police are protecting the interest of their constitutional duties and so on. Now, the letter that I referred Your Lordship to, I won't read, but I want to say that Your Lordship must be satisfied that the law enforcement agencies have found it necessary not to oppose the application because of the aggravated situation in the country around this matter. Your Lordship, with the greatest respect, can take judicial notice of the fact that, this matter has understandably provoked the interest, to put it mildly, of many people in the country for obvious reasons. We're dealing here with a former head of state and so on. And what is telling, my Lord, is paragraph 8 of that letter.
Yeah.
Where the police and the president say, through the mouth of the state attorney, in view of the unique situation presented by the developments and the legal matrix involved, our clients will, out of respect of the unfolding litigation, hold further actions they are expected to take in terms of the Honorable Court's orders in abeyance, pending the finalization of the litigation, alternatively pending any directions by the Honorable Acting Chief Justice may possibly issue regarding the conduct of the litigation and any other matters relevant to the litigation. Putting aside the fact that they say pending the Acting Chief Justice, which I'm sure they didn't mean it, hopefully not literally, because the Acting Chief Justice is a party in these proceedings. But let's put that aside. The emphasis I want to put is the unique situation presented by this development. And I'm respectfully saying that Your Lordship will know that those unique circumstances include the volatile security situation that may be posed by this matter. Now, here's the question, my Lord, and I'm going to leave this point to come to Your Lordship's question, but I want to leave it with a rhetorical question. If then, my Lord, the parties that are constitutionally empowered, including the President, constitutionally empowered to assess the security situation, to execute the warrant, have found it necessary in the interest of justice. Remember, the police mandate from the Constitution is covers the interest of justice, to hold this execution of the warrant in abeyance. Then what business is it of an NGO and some commission whose duty is to inspect or to examine and investigate state capture and try and use our taxpayers' money as frugally as possible in that pursuit, to travel metaphorically or otherwise all the way to Pietermaritzburg to oppose that which the constitutional bodies tasked with the body with this particular difficult task have agreed.
I could be wrong, Mr. Mpofu, but the way I see the fourth and fifth respondents' affidavit, especially paragraph 7, unfortunately I don't have the paginated papers. I'll just refer to paragraph 7 of the answering affidavit.
Yeah.
What that paragraph seems to indicate is that actually your salvation doesn't lie with this court. It lies with the Constitutional Court.
Yes.
Yes, that's what it seems to suggest. Yes.
Yes. Okay, my lord. Let's then come. Yes. No, that's why I was saying I'm leaving it with that rhetorical question.
Okay.
So let's then come to that issue, my lord. Well, my lord, there is no. That issue really has no substance whatsoever. It is based on the false assumption that the court that issues an order has exclusive, underline exclusive, jurisdiction to enforce that order. Now, there are two principal issues, my lord, that are fatal to that analysis. One is the one that I was touching on of what is the nature of the proceedings before your lordship. The nature of those proceedings is an interdict pendente lite. That phrase pendente lite is just a lawyer's jargon for a simple proposition that pending litigation. Now, the problem is that there is established law, my lord, and I will take your lordship there, that it is not necessary for a court that would otherwise have jurisdiction, such as this one, to be enforcing an order of its own. In other words, I will show your lordship that a court in this country, a high court in particular, has inherent jurisdiction and national jurisdiction to enforce court orders, even of other courts, in other words, of other provinces, even of other tribunals, such as arbitration, and even, which most people would find difficult to believe, of something that needs to be done in a foreign jurisdiction, where that court, the High Court, your lordship would have no other way of reaching that country. Let's say the person is sitting in England or whatever. But in the unique circumstances of an interdict pendente lite, your lordship would, it's one of the exceptional circumstances where your lordship would even be able to grant a relief against a peregrinus or somebody who's outside, who has fled outside of the country. Why is that so? It is so, my lord, because when the court, and in this court, my lord, let's emphasize this, there's no contestation of the fact that this court would otherwise have jurisdiction. In other words, that the defendant is found within the jurisdiction of the court. The execution of the warrant would be in the Nkandla police station and in correctional facilities that are within the jurisdiction of this court. So the only thing that is being said is that that is not sufficient, simply because this is the order of another court. In other words, my lord, if you take away, what I'm saying is that there's no contestation of territorial jurisdiction. What is being said is what your lordship is putting to me, namely, does the High Court, any High Court, assume I'm right that any High Court has got national jurisdiction with in these circumstances, does the High Court have jurisdiction to enforce an order of a higher court? I think that's the gist, as your lordship correctly summarized the situation. Now, my lord, the situation is, let's start at the basic level by the mere proposition that says that an interim order may be enforced against the order of another court. And my lord, if your lordship received the heads, and I apologize that the photocopying is not the best in the world, but if your lordship goes to there's an attachment there.
Yes.
Which is from Pollack on jurisdiction, the highest authority on jurisdiction matters. If your lordship goes to page 117, I don't know if it's visible on your lordship's copy.
Yes, I have it, 117.
Yes, insofar as it is cut there, it is cut off. I will read it out, that passage, my lord. And in fact, your lordship would find that in our heads, it's reproduced at paragraph 23, my lord. Page 10.
Yes.
Yes. Now it says, in the case of an interdict pendente lite, which is what we have here, it does not matter that the lease, in other words, the main action in question is before another court, even a foreign court, nor that the pending issue between the parties is subject to determination by a tribunal or body other than a court of law. So that's what I call the basic submission, my lord. That it does not matter, this is the proposition I've made earlier, it's a starting point, that the main action is before another court, in this case, the Constitutional Court, or a foreign court, or it's a pending issue between the parties subject to determination by a tribunal other than a court of law. Why is that so, my lord? It is because of the nature of proceedings pendente lite. So the lite part, the litigation, the actual litigation pending which we are before your lordship, need not be in your lordship's within your lordship's jurisdiction. That's obvious from that statement. And my lord, let me say this very quickly. In jurisdiction issues, remember, often, like in this case, the respondents might ask the wrong question. And the wrong question is there another court that may have jurisdiction? That's the wrong question, and that's answered by the passage I've just read. That is not the question. The question is, does this court, your lordship's court, have jurisdiction? The fact that your lordship's court might have jurisdiction concurrent with another court or shared with another province or whatever is neither here nor there. The simple question is whether your lordship has jurisdiction or not. And that your lordship knows is a well-established principle in Kaba, Chirwa, all those cases that have to do with the concurrent jurisdiction of the labor court, for example, with the high court. Makanya's case, the SCA case, also says the same thing, my lord, that you must not ask if another court has jurisdiction. Look at the pleadings of this case and ask whether this court has jurisdiction. And we say, my lord, that this court does not have to preempt the main action. All this court must be interested in. Do I have in front of me an applicant who meets the requirements for the relief that is sought? And that is important, my lord, because remember there are two types of reliefs before your lordship. One is, let's call it a common law interdict, the normal common law interdict. The other one is a suspension order in terms of section 172 of the Constitution. That's the nature of the relief sought before your lordship.
Yes.
I don't think there's anyone who can argue that your lordship does not have jurisdiction to issue a suspension order in terms of section 172 of the Constitution. If there is such a person, then they will be hugely mistaken. So even at that level, my lord, the jurisdiction of this court is engaged almost directly. But I'm prepared to even go further, my lord, and say, even if your lordship did not have the section 172 relief before you, and you only had the common law interdict, pendente lite, the lordship would still have the jurisdiction on the basis that I have already articulated, which I will develop again just now. But this debate actually should just end at the point at which your lordship is satisfied that your lordship has jurisdiction in terms of section 172 of the Constitution for a suspension order. And this is what the other side is missing, my lord, a lot, because they have not addressed at all the relief that is sought in terms of section 172 1B in their so-called jurisdiction challenge. And my lord, if I may just show your lordship that this distinction was made very recently in the Constitutional Court by Chapter J, speaking for the the court, for the unanimous court, in his concurring judgment in Economic Freedom Fighters versus Godin. Your lordship might remember that this was a debate about the EFF in that case had brought an action to say that remedial action of the public protector may be implemented even though there is a legal challenge. Or to put it the other side of the coin, Minister Godin had interdicted such implementation of the remedial order. Same as here, the execution of the order, so to speak. And of course, the majority judgment in the Constitutional Court of Hampempe, DCJ, I think ADCJ, as she then was, found that the common law interdict was not well founded using the well-known outer principles. But the significance of the judgment of Chapter J, my lord, was that it agreed with the first judgment, but based it on a different footing, on the basis that what was really being sought here was a suspension order, as opposed to a conventional interim interdict. And that suspension order is founded on section 172 of the Constitution. This is what he said, my lord, at paragraph 113. And I will emphasize 113 and 114. He said, therefore, even if it could be said that there were prospects against the grant of the interdict, in other words, the common law interdict, the applicants for leave would still be faced with the question whether there were prospects against suspension. And here's the important part. The requirements for suspension differ from those needed for an interim interdict. The outer standard does not apply to suspension and all the other standard. We can also add that, my lord. Then he says in paragraph 114, the power to suspend the operation of the public protector's remedial action is sourced from section 172(1)(b) of the Constitution. If in a matter like the present, it is considered just and equitable to suspend a remedial action pending the determination of the review in which the validity of the remedial action is impugned, a court may grant the suspension. Guidance for issuing the suspension is derived from considerations of justice and equity. And at 115, a determination of a just and equitable order of necessity requires a careful consideration of interest of parties on both sides of the litigation. The order must be fair and just when all the relevant factors are taken into account. What is just and equitable in a given case depends on the facts of that particular case. This sort of inquiry entails a flexible approach in pursuit of justice and equity in every matter. So what am I saying, my lord? I'm saying that put aside issues of the common law interdict. This court clearly has jurisdiction. Paragraph 75 of the Zuma case, my lord, says that, the well-known Zuma case says that it is the pleadings that must guide questions of jurisdiction. What has been pleaded here is a section 172 attack as well as a common law attack. So let's say for argument's sake, your lordship did not have jurisdiction based on the interdependently common law interdict. Your lordship would still have jurisdiction based on the section 172 case that has been pleaded before your lordship. And that would be the end of the matter. Secondly, and I will come back to show your lordship that even on the common law interdict, your lordship has got jurisdiction. But couple what I've just said, my lord, with the following. And that is what I was saying, that the two cardinal mistakes committed by these respondents is not to understand the nature of the proceedings as far as the common law cause of action is concerned. But also not to understand the nature of the relief that is sought in the main application. And if your lordship allows me just to pack the issue of the jurisdiction a la common law pendente interdict, just to jump to part B, what we call part B. Yes. The Commission and Justice Zondo fail completely to address the relief referred to in part B, and it's for understandable reasons, because there's no answer to it. The Helen Suzman Foundation, for its part, tries, for what it is worth, to say that no, the relief in part B is not its prospects are weak and so on. And I'll show that that's not a real defense. Firstly, because they do not have the standing, as I said earlier, but also because the primary defendant, your lordship knows very well that when you attack the constitutionality of the Criminal Procedure Act and those kinds of statutes, the primary defendant there is the Minister of Justice. That is the third respondent. And the third respondent against whom that order is really sought, that declarator of unconstitutionality, as your lordship has already remarked on this, is not opposing. So here's the thing then, my lord. If, as we all know, in fact, let me be bold and to say this, that again, I don't think anybody, at least not my learned friends on the other side, knowing them as I do, will contest the proposition that this court has got, and I'm putting this deliberately like this, exclusive immediate jurisdiction over Part B. Let me explain what I mean by that, my lord. This court, in terms of the Constitution, Section 167(5) of the Constitution, is the only court in this country that may entertain Part B primarily. And I use the word primarily because your lordship knows, as everyone knows who practices in this court, that an order for unconstitutionality starts in the High Court, and then it gets confirmed by the Constitutional Court. But the Constitutional Court has said in many, it's tried, I don't think any of my learned friends will contest this. It has said that it would be improper for it, the Constitutional Court, to consider an attack on the validity of a statute as the court of first instance, for obvious reasons. It even implores judges in the lower courts, like your lordship, to, when making those orders, to give full reasons so that the Constitutional Court would have the benefit of those reasons. So, Section 167(5), my lord, says, of the Constitution says the following. The Constitutional Court makes the final decision whether an act of Parliament, a provincial act, conduct of the President is constitutional and must confirm any order of invalidity made by the Supreme Court of Appeal, a High Court, that is like the Pietermaritzburg High Court, or a court of similar status before that order has any force. So I'm saying, my lord, that any reading of that subsection clearly says that the primary court that must assess the invalidity of a statute is the High Court or a court of similar status. And your lordship will know that there was a debate recently as to whether the Labour Court, for example, qualifies as a court of similar status, and it was found that it does. In other words, the Labour Court can also declare a statute invalidity. So the jurisdiction, the primary jurisdiction of invalidating a court at least lies in two places: in the High Court, such as your court, my lord, and in the Labour Court. Now, in which world, my lord, can it be said that when you are seeking relief pendente lite, where the lite part of that Latin expression is exclusively before your lordship, can only be determined by the High Court? And then it is said that your lordship does not have jurisdiction to give interim relief. That would be the height of absurdity, my lord. And again, I put in brackets, the fact that there may be another court that also has jurisdiction is neither here nor there. Let us at least agree, as I'm sure my learned friends will agree, that A, your lordship has got jurisdiction in terms of Part A because it seeks a suspension order for starters under Section 172. And it seeks a suspension order pending and Part B, over which the High Court also has exclusive jurisdiction. So it's a double-barreled jurisdiction of your lordship. So your lordship has got jurisdiction on those two separate grounds, Section 172 and the basis and because of Part B. But let's come to the other basis, my lord, because it will overcome once and for all this fear or this, well, it's not real, it's a scarecrow tactic about whether simply because this other order now comes from the Constitutional Court, the law must change in relation to the common law interdict. Well, my lord, at the risk of repeating myself, if we accept that another court in this context can include the Constitutional Court, and that therefore your lordship's order, I'm now referring back to what Pollack says, your lordship's order can affect or rather extend to the main proceedings which are in front of another court. By the way, my lord, I would recommend that your lordship read the first part of Pollack, the first 2 pages. I won't go into it. It deals with the notion that if the act, it says just above the part that I read, says, if the defendant or respondent is an incola of the area over which it exercises jurisdiction, the court may exercise that jurisdiction irrespective of where within the Republic the seat of the act which is to be prevented or compelled is to be done. And then a little bit further down, if, however, the defendant or respondent is a peregrinus in the area over which it exercises jurisdiction, the court may act only if, in the case of a mandatory interdict, the order is to be carried out within such area. In the case of a prohibitory interdict, which is what we're dealing with here, that distinction is also important. This is a prohibitory interdict, and therefore the rules are different between a prohibitory interdict and a mandatory interdict. So in the case of a prohibitory interdict, the act against which, and I apologize, my lord, for the underlining, it came from some original underlining that was in the book. The act against which an interdict is claimed is being done or is about to be done in such area. What is the act in this case is the arrest and the committer. So, and as I said earlier, there's no doubt that the act against which the interdict is claimed will be done or is about to be done in your lordship's area. So your lordship has jurisdiction on that ground alone. Now, here's the question then, my lord. If your lordship has got jurisdiction on those 3 separate grounds, Section 172, the fact that the Part B is before your lordship, and thirdly, because the act against which the interdict is claimed is being done or is about to be done in your lordship's area, on what basis can the inherent jurisdiction, put on top of that the fact that the High Court has got inherent jurisdiction in terms of Section 173 in any event to do anything that it is not prohibited from doing, so to speak. And that's crucial, my lord. remember that the High Court has jurisdiction to perform all acts inherently from which it is not excluded.
Yes, but it talks about their own process.
No.
Their
Yes.
own process.
No, but my lord, with the greatest respect, that is really the worst attempt to put the words of Section 173 when it says the courts must direct their own processes.
Yeah, it
does not mean
has the inherent power to
Yeah.
protect and regulate their own process.
Yes, my lord.
Yes,
But
that's what it says there.
yes, it simply means to regulate your internal process. But it does not mean that you now lose the inherent jurisdiction that I've just read out, for example, in Pollack, to give an interim interdict against an arbitration proceedings, for example, as Pollack says, because the arbitration proceeding is not your own process. That interpretation of those words, my lord, is completely misplaced, with the greatest respect. It does not mean that at all. It simply means that your lordship has got inherent jurisdiction to regulate your process where the rules, for example, where there's a gap. But it cannot possibly or conceivably mean that your lordship jurisdiction is ousted simply because the other matter now suddenly is before another province or a foreign jurisdiction or an arbitrator, surely. So that is a real feeble attempt to interpret those words. They could never have been meant in that restrictive sense. But my lord, let's not be waylaid into Section 173, because quite frankly, we don't need Section 173. I've demonstrated to your lordship that your lordship has got jurisdiction on basis of 172. Your lordship has jurisdiction on the basis of Part B and of the common law jurisdiction grounds. I was simply expanding to say your lordship, in any event, the jurisdiction I was talking about, my lord, does not come from 173. It comes from the primary jurisdiction of your court, which is Section 169 of the Constitution. Which says, a high court, such as your lordship, may decide, one, any constitutional matter. Let's just pause there. There can be no doubt that what we're dealing with here is a constitutional matter, in that it invokes the fundamental rights of the appellant, not to be arrested and not to be detained without trial and so on. So nobody is going to argue that this is not a constitutional matter. And then here it says, except, in other words, you must read Section 173 with 169, otherwise 173 will be in a vacuum. So it says any constitutional matter in the world, well, not in the world, in the country at least, except a matter that is one, only in the constitutional, that only the Constitutional Court may decide, or that is assigned by an act of parliament to another court of a status similar to a high court. So let's forget about number two, that's the labor court, water court, or land court, or whatever, which might be a court of equal status. And then any other matter not assigned to another court by an act of parliament. Again, that covers those special. So let's concentrate on Section 169(1)(a) Roman 1. Any constitutional matter except a matter that only the Constitutional Court may decide. Now, what that means, my lord, is if you want to know the real ambit of your jurisdiction, you have to go read 169.1a, Roman 1, and read it together with 167.4 of the Constitution. (167.4), as your Lordship knows very well, is the list where it says only the Constitutional Court may decide, and then it lists A to F. Your Lordship knows those. What does that really mean? If you synthesize the two submissions, it is that 169 is really saying a High Court may decide any constitutional matter except a matter listed in section 167.4. And there is nobody, again, at least not in this hearing, who's going to argue that the matter before your Lordship falls under 167.4, because it doesn't. Right? So again, your Lordship has got jurisdiction over, this is the fourth basis now that your Lordship has jurisdiction. It is because 169A does not oust the jurisdiction of this court in its articulation of the wide ambit of the jurisdiction of this court, read with section 173. So again, that's another demonstration that the restrictive interpretation which is sought to be placed on the words of processes or its own processes is just completely unfounded. Now, my Lord, the fifth and last basis upon which your Lordship has got jurisdiction is the following. And this, my Lord, should put to bed any lingering doubt or doubt that may linger in your Lordship's mind as to whether the Lordship has jurisdiction in this matter. Maybe let me just preface this, my Lord, by telling your Lordship up front where I'm going, and then I'll take it step by step. Because the proposition I'm going to make at the end is what we call an a fortiori reasoning.
Yes.
And it is this, my Lord. If this court, your Lordship's court, would have jurisdiction to grant an interdict, even in a situation where the main proceedings were proceedings that fell within the exclusive jurisdiction of the Constitutional Court, then a fortiori, your Lordship must have jurisdiction in a situation where the proceedings do not even fall under the exclusive jurisdiction of the Constitutional Court. I'm sure your Lordship follows the logic of the submission.
Yes.
Yes, thank you, my Lord. Now, I've just demonstrated to your Lordship that the case before your Lordship does not fall under section 167.4, and I don't expect that to be disputed. So let us then take the higher situation where the main application would actually be about, let's say, the conduct of the president, the parliament, and all those things that are listed in 167.4. This proposition, my Lord, must be understood within the background of the submission of what I said earlier, my Lord, about the nature of the proceedings. That these are proceedings of an interdict pendente lite, And I'll refer your Lordship later to the case of Piccoli that explains the impact of such proceedings. I'll refer your Lordship later, just so that we don't break this thought. Now, my Lord, the Constitutional Court has had this to say about that situation. And your Lordship will find that in the case that we refer to in our heads, the Lordship will find that at paragraph 26 of our heads.
Yes.
Is the Lordship there? Thank you, my Lord.
Yes.
Yeah, it's the case of National Gambling Board versus Premier of KwaZulu-Natal, where the Constitutional Court said unanimously, the citation is at the bottom, my Lord, 2002, volume 2, SA 715, Constitutional Court. And I'm going to read from paragraph 49 and 50. And I'm going to read it, yes, just those two paragraphs. It says, the Constitutional Court said, in an application for an interim interdict, the dispute is whether, applying the relevant legal requirements, the status quo should be preserved or restored pending the decision of the main dispute. I may pause there, my Lord. That is why these orders are called status quo orders. An interim interdict pendente lite, it has been said, is to freeze, quote unquote, the status quo pending the main action. In this particular case, what is the status quo? The status quo is that the former president is not arrested, to put it colloquially, and is sitting at home and watching these proceedings. So the purpose of an interim interdict pendente lite is to freeze that status quo until the main action has been determined. In other words, until the Constitutional Court has finally determined the outcome of the main dispute. And then it says, at common law, I'm continuing with the quotation, a court's jurisdiction to entertain an application for an interim interdict depends on whether it has jurisdiction to preserve or restore the status quo. Let me pause again. Whether it, in other words, the High Court, has jurisdiction to restore or freeze the status quo, which is that the president who is within its jurisdiction is sitting at home. And here's the punchline. It does not depend on whether it has jurisdiction to decide the main dispute. It can never be clearer than that, right? It does not depend on whether this court has the jurisdiction to decide the main dispute. In other words, the rescission application. It does not. Contrary to what you've been told and what is being bandied about in the media by experts, so-called. It does not depend on whether the court has jurisdiction to decide. And here it goes, my Lord, on paragraph 50. Whether a high court will have jurisdiction to grant interim relief pending a matter exclusively within this court's jurisdiction, in other words, the Constitutional Court, does not depend on the form or effect of the interim relief. Now read that again. Whether a court will have jurisdiction to grant interim relief pending a matter exclusively within this court's jurisdiction does not depend on the form or effect of the interim relief. It depends on the proper interpretation of the relevant provision and on the substance of the order. Right? So what is the substance of the order here? We've already said Section 172 and the common law order and the Part B consideration. And they said, does it involve a final determination of the rights of the parties, or does it affect such a final determination? If it does not, as it clearly does not here, the High Court will, depending on the provision that grants exclusive jurisdiction, have jurisdiction to grant interim relief. Right? In other words, your Lordship would have jurisdiction even in a situation where the main relief was within the exclusive jurisdiction of the Constitutional Court. So, if, my Lord, that is so, then with the greatest, and remember, my Lord, we're dealing here, in fact, this is a classical situation that applies that a fortiori rule.
Yes.
I'm sorry, my Lord.
Yes.
Now, I'm saying, my Lord, that remember, this is a situation where actually contrast that with the situation of exclusive jurisdiction. What we have here is the exact opposite. Rule 42, as your Lordship knows, actually is a rule of the High Court. It comes from the Uniform Rules of Court. It just so happens that the Constitutional Court borrowed the rule by the expediency of Rule 29 of the Constitutional Court rules. So far from being a situation where there could be any talk of exclusive jurisdiction by the High Court, we have here a situation where the main application is actually being determined according to the rules of your Lordship's court, which is the High Court. So how can it be then argued, my Lord, that your Lordship does not have jurisdiction to grant interim relief pending a matter which is not even within the exclusive jurisdiction of the Constitutional Court? Then, my Lord, as far as if there's any need still to give your Lordship the sixth basis, the Lordship, I'll refer your Lordship, and I won't develop this point much further, to Rule 45A of your Lordship's, of the Uniform Rules of Court. And the importance of this, we might as well make it half a dozen reasons. Rule 45A says the following, my Lord. The court, meaning the High Court, may, on application, suspend the operation and execution of any order for such period as it may deem fit, provided that in the case of appeal, such suspension is in compliance with Section 18 of the Act. And I'll explain to your Lordship why that is so important. Now, here's the importance of that, my lord. And this goes back to really to the philosophical foundations of this whole suspension story, as your lordship knows, is based really on the following constitutional proposition, which underpins Section 18 of the Superior Courts Act. It would be unjust, for obvious reasons, that if you appeal, and I know this is not an appeal, and I'll explain the connection, my lord. The connection is the one made. The Section 18, as the lordship knows, applies to appeals. But forget the nitty-gritties. Let's look at what is the philosophical foundation. The philosophical foundation is that if you appeal, or rather, if you, let me put it in a neutral fashion, if you have other proceedings whose aim is to set aside the order, whether it will be set aside as a result of an appeal or a rescission order, for the purposes of this discussion, is neither here nor there. The lordship knows that one of the orders that we seek in the Constitutional Court's notice of motion is the setting aside. I think it's order number, it's JZ2, my lord. If your lordship doesn't have paginated papers.
What page?
On the paginated papers, it's page 39. It's the, your lordship will remember there are just two annexures to the, your lordship. Prayer 2, my lord.
2, okay.
I mean prayer 3, I'm sorry, my lord.
Yes.
The lordship will know that one of the orders we seek is for paragraphs 3, 4, and 5, and 6 of the order of the court to be set aside. Right? Following on the rescission. What I'm trying to say, my lord, is that I'm jumping the reason for the setting aside deliberately. So I'm saying whether the setting aside is going to happen as a result of an appeal or a rescission for the purposes of this argument is not relevant. The foundational philosophy is that if there is a threat that the order may be set aside, then the execution of that order, in the case of an appeal, is automatically suspended, automatically, in terms of Section 18. So the only difference is that that situation is regulated by statute. So it's automatic.
With the appeals as well.
Well, my lord, I'm explaining that that distinction is irrelevant for the purposes of what I'm saying. It deals with the setting an order that is likely to be set aside, and whether it will be set aside as a result of an appeal or a rescission for the purposes of this argument is irrelevant. Your lordship is quite correct. As far as it deals with appeals, until 2010, that situation was like the situation you have here, determined by the common law. So it really doesn't matter that it just so happens that in that case, the statute, the legislature saw it fit to codify the common law. But what I'm trying to say to your lordship is that the common law foundations of not executing an order that is liable to be set aside remain intact. And that is why Rule 45, in a way, specifies that the Section 18 situation is catered for by Section 18. But Rule 45, therefore, caters for other situations, such as the one in front of your lordship, not the one that is catered for in section 18. And therefore, this court, there can be no doubt on that basis as well that apart from section 18 orders or appeal situations or application for leave to appeal, this court has jurisdiction as well based on section 45 to suspend any order. So I hope then, my lord, with those 6 reasons, it covers the full ground of the jurisdiction for over any order, jurisdiction for an order of another court, jurisdiction over a court of where there it might even lie exclusively in the Constitutional Court. In that matrix, my lord, there is no room whatsoever for this argument that your lordship does not have jurisdiction over the main action. And I'm saying, my lord, even in the unlikely event that your lordship did not have jurisdiction simply because this is a rescission and not an appeal. And your lordship knows, by the way, from the case of Zuma, that it has been said that section 18 applies to appeals that go right up to the Constitutional Court. So a fortiori, again, the suspension would apply to those situations as well. But so that's not reason number 7. So even if your lordship was somehow reticent on the last part of this so-called objection, that this is the decision of a higher court, then your lordship would be comforted by the 8th reason, which is what the so-called once and for all rule. And that rule, as your lordship knows, gives jurisdiction to a court, even if there are 3 or 4 causes of action, and one of the causes of action the court doesn't have jurisdiction over. The court has inherent jurisdiction to assume jurisdiction over that 3rd or 4th cause of action on the basis that a dispute must be resolved once and for all. That's an old common law rule. But I'll stop there, my lord. I'm sure we can go on all day to find reasons for jurisdiction.
Yes. Should we carry on, or should we take a short break and for 30 minutes and then reconvene? What? My
lord, if your lordship would just allow me to maybe just to round off this point. Yeah. So that then if you take a short break, I'll just deal, the issues on the merits are very simple. I'll deal with them.
But it's still, everyone is still comfortable that we carry on, because I'm quite happy that we carry on.
Okay, then I'm definitely comfortable. I don't know about my learned friends.
Yes.
Mr. Mukatobi is nodding.
Okay, we're fine. We'll carry on.
Thank you.
Yes.
Thank you, my lord. So, my lord, let's put aside then those 8 reasons why your lordship has jurisdiction. And then come to the only other remaining, your lordship is quite right. The only obstacle that was posed on your lordship's path was this so-called jurisdiction objection, which I'm quite sure we would have put paid to. The other one, of course, is an attempt to invite your lordship improperly, with the greatest respect, to reach the actual rescission application. And I would say, my lord, that it is improper for your lordship to be asked to do that for various reasons. Your lordship needs only, if your lordship wants to ask me any question, and I will give your lordship just the few what we call highlights as to why the rescission application is an extraordinary one and one that must not be taken lightly in the present circumstances. Your Lordship, the reason why, my Lord, we attached the full application in the Constitutional Court was so that Your Lordship can appreciate the extent to which, as the minority judgment puts it, the majority judgment did not see the woods for the trees and gave an order which is unconstitutional and undermines the constitutional rights of the appellant to a fair trial and not to be detained without trial. I don't have to convince this court that Section 12(1)(b) of the Constitution thankfully outlawed detention without trial, so that those of us who were victims to it can rest with thought after 1994.
Yes, but I think those issues really will be ventilated in the Constitutional Court, I think.
Aha, that is exact. Then Your Lordship and I, yes, then Your Lordship and I we're on the same page. All I'm saying, my Lord, is that the invitation for Your Lordship to reach those issues is improper. So I agree with Your Lordship.
Yeah.
Not only because the main application covers the most fundamental. I have never seen a situation where the judges of the Constitutional Court say that this judgment is unconstitutional. That's a very, very sobering statement, my Lord. Because what it means is this. The court, remember, there's a misapprehension which people might have, that what is actually supreme is the Constitutional Court or any court. Well, that is not true. What is supreme is the Constitution. And no institution, including a court, including a president, including anybody, because thank God we don't live in a monarchy where there's a so-called prerogative. So there's no institution in this country that has the right to exceed its powers and breach the Constitution or act unconstitutionally, even the court. And if it is true, my Lord, it's a big if. If it is true, and if there's even a possibility that in the rescission application, it will be found that the majority acted unconstitutionally and breached the Section 12 rights of detention without trial rights of the accused person or the appellant, as far as the hybrid situation is concerned, or even the 35(3) rights, or any rights, the rights to dignity, the rights to equal treatment, all the rights that we have invoked. If that is a possibility, and it must be a possibility, my Lord, because no less than the Constitutional Court of this country has done what is another extraordinary feat, and I'm sure my learned friends will agree, that it is only in a few cases where the Constitutional Court has done what it has done in this case, which was to issue directions for a hearing of a matter literally within 24 hours of the lodgement of the papers. And as I say, it's usually done in those electoral matters where the election is tomorrow and so on and so on. But it's one of the rarest things ever to be witnessed. Thank you, my Lord. And your Lordship will know that those of us who practice in that court at least will know that that is a rare occurrence. To make it worse, my lord, for those 24-hour instant directions to be granted on a Saturday. In other words, the court could not even wait. We submitted our papers in the late afternoon on Friday. And those were not, by the way, urgent papers. And the urgent application is the one before your lordship. But the court, in its wisdom, decided that it could not even wait until Monday to issue those directions. And your lordship, once again, must read between the lines with respect. Your lordship must read between the lines of why the police, the National Commissioner, Minister of Justice, the President have not opposed this matter and are quite happy that your lordship should grant the relief that is sought, and why the Constitutional Court gave urgent directions on a Saturday, which were not asked for by anybody. And if your lordship, despite all that, can read that no, and despite, let's go back to our assumption, assuming that the matter is unopposed, as I respectfully submit, the lordship can say, well, on all those circumstances, the fact that we're dealing with the possible arrest of a 79-year-old person whose health condition is uncontestedly precarious, to say the least, who is not a flight risk, who, when the rescission application is all finished, if he is unsuccessful, will duly face the consequences of that lack of success. In all those circumstances, then why on earth, my lord, would anyone say that there is any, even if you look at the balance of convenience test or any other test that your lordship has under the common law, what is the harm that these respondents will suffer if the order is suspended, as opposed to any harm? I'm sorry, my lord.
So, on the seat of the directions from the Constitutional Court, did you consider to, approaching the Constitutional Court and ask to stay the execution of their order?
No, my lord. You can't do that. That is why, my lord.
Why?
Because
yes, carry on. Yes.
No. Let me get your lordship's full question.
Yes, I'm saying once you received the directions, saying that your matter would be dealt with on the 12th of July. Did you consider approaching the Constitutional Court and say to them, look, now that you have given us a date for the 12th of July, can you then consider staying the execution of your order until that date, the 12th of July?
Well, my lord, let me put it like this. Your lordship will see from the factual matrix that the applicant, former President Jacob Zuma, one of the things that brings him to this situation, by the way, is the fact that he says that he is unable to fund litigation which is unnecessary. That's what got him into the soup in the first place. Because, as your lordship knows, he was of the view that because the prospects of the urgent direct access application in the Constitutional Court, according to his advice, which I would have given myself, and I think any reasonable lawyer would have given, the prospects of the Constitutional Court of this country hearing a matter like that on an urgent basis and on a direct access basis, given the matters that they have rejected, which are more meritorious, were slim, let's put it like that. And it was for that reason that and with hindsight, of course, Your Lordship knows that that turned out to be wrong. But we must place our minds at the position that he was in December before the order was granted. That was one of the reasons why he did not oppose that application. And I can assure you that might even be one of the reasons why those people are not opposing the application before Your Lordship, because it's a usual reason. This day and age, litigation is expensive. So you don't just engage in litigation just for the sake of the textbooks, for theoretical reasons. So why would the former president, my lord, when he has lodged an application in this court,
yes,
obviously, and Your Lordship, again, hindsight, as they say, everyone is clever after hindsight. Remember, on Friday, Your Lordship, the applicant did not know that the Constitutional Court was going to issue directions on Saturday, right? So we must always put ourselves in the shoes of the person. So on Friday...
But normally, when you want to stay the execution of an order, especially in a rescission application, that forms part of the application that you make to that particular court. And I said, please don't execute your order pending the outcome of the decision application. That's what you normally do. Yes.
Yes. Well, then that's a different question, my lord. I thought Your Lordship was saying once the directions were issued. Well, let's answer
yes.
the different question. Well, the first question I've answered, as I said, once the directions were issued, it already he had a pending action, and it would have been foolhardy and wasteful for him to say, oh, well, now I'm going to withdraw the other application. And so
I understand, yes.
Yes. But the answer to the second question, which is a different matter altogether, is the following. It goes back to what we said about the Gaba, Chirwa, and those kinds of cases. Our law is very clear, my lord. If there are two courts that both have concurrent jurisdiction over a matter, then that's the classical example of concurrent jurisdiction. Then you don't ask that question. Why did you not go to the other court? And that's where we started this morning. You only ask, does this court have jurisdiction? And if the answer to that question is yes, the mere fact that there may be another court that has equally concurrent jurisdiction is mightily irrelevant, because it is the election for whatever purpose of an applicant, for example, in a labor matter, who has been unlawfully terminated. Once they make an election and say, I'm going to go to the labor court, then they must stay with that election. But if they make the election to say, I'm going to go to the high court, you can't say, but you should have gone to it's a secular argument. You should have gone to the labor court, because they'll say, yes, I know I could have gone to the labor court, but I came here. So the only question is, do you have jurisdiction? You can't kick him out on the basis that he could have also gone to the labor court. That would be exactly what the Constitutional Court in Gaba said you cannot do, because you must look at the pleadings of that particular case, and not whether he could have gone to the water court or the land court. That may well be so, but the question is the wrong question to pose. And you might even say, oh, well, it might be cheaper in the labor court, or it would have been set down quicker than in the high court. Well, so what? The litigant would have elected to come to a court that also has jurisdiction. So that question, with the greatest respect, does not arise in the earlier situation. Besides, my lord, it goes back to what one might call prudence or the economics of litigation. imagine, my lord, if even the richest litigant in the world, if they were to say, okay, I've got this Part B, which is exclusively in the jurisdiction of the Pietermaritzburg High Court. I also have an interim interdict, which in terms of section 172, is within the jurisdiction of the Pietermaritzburg Court. And I also have a third cause of action, which is in the jurisdiction of the Pietermaritzburg Court, but also in the jurisdiction of the Constitutional Court. So, but now I'm going to bring two actions, one in the Constitutional Court and another one in Pietermaritzburg. That would be a foolhardy way of litigating, because it goes back to what we call the once and for all rule. It would, even in those circumstances, be open to that litigant to say, well, I already have these two causes of action over which the Pietermaritzburg High Court has jurisdiction, and therefore, even this third one, even if, as I indicated from the gambling board case, even if that third cause of action was lied in the exclusive jurisdiction of the Constitutional Court, this court would have, under Section 173, jurisdiction to regulate, to say, well, this situation is not foreseen by the rules, but clearly, are we really going to send one litigant to two separate courts for the same thing? So I'm afraid that question, with the greatest respect, my lord, does not arise at all. If it does, it really would be forcing an applicant to litigate in two different places, or three, for example. Let's assume the third cause of action lied in the Land Act. Then he would have had to issue in the Maritzburg High Court for Part B, and issue in the Land Act for the other part, and issue in the Constitutional Court for Part C, let's say, quote unquote. And that, by the way, my lord, is how your lordship should look at this. Look at, conceptually, look at the rescission application as, let's call it Part C. So your lordship has got Part A in front of you, and this litigant has got Part B, over which your lordship has jurisdiction, and then Part C, over which your lordship has concurrent jurisdiction. Then what's wrong if the litigant brings it to you? Imagine the opposite, my lord. Imagine if he had said, okay, no, I'm actually going to go to the Constitutional Court and raise the issue of the suspension of the order there. And somewhere, because I'm already there, I'm also going to raise the unconstitutionality of the Criminal Procedure Act. Then he would be laughed out of court, because the Constitutional Court would say, yes, we know that we have concurrent jurisdiction over the rescission application, but why on earth are you here for your Part B? Because you know that only the High Court has primary exclusive jurisdiction over that. So that would not work either. So the only option then he would have, my lord, is not a place where he could have brought both of his actions together. The only option is the absurdity of having to bring them in two separate places when one of those places has got jurisdiction over both, which is your lordship's court. That would be not just imprudent, but absurd. So my lord, we just got back to this, but I was actually dealing with the merits here. And I appreciate your lordship's opportunity to address that, because that's a valid question as to how the choice is made at a particular point. Firstly, I'm saying one must put yourself into where he was on Friday, and secondly, put yourself into where he was on Saturday, once the directions of the Constitutional Court were issued, where he would have had, if one followed your lordship, that advice, he would have had to then withdraw a portion of what is before your lordship and bring it in another place, and still come here on Tuesday. And I mean, that's just unwieldy and unworkable and unadvisable, ill-advisable. But the only point I was making, my lord, on the merits was that your lordship, with the greatest respect, cannot second guess the outcome of the rescission application itself. And your lordship has already said that. And I therefore won't go into your lordship about the section 12, the detention without trial and all those issues. Because those are the issues that the Constitutional Court, in its wisdom, at the very least, your lordship owes the Constitutional Court that to defer, that deference to it. I know that the directions of the Constitutional Court cannot be elevated into a court order. We don't make that absurd proposition. But it is there, my lord. We say in our heads, the fact that it is there at the same time cannot be ignored as if it does not exist. So your lordship must give it some legal effect, not as much legal effect as if it were a court order, obviously, but not zero legal effect as if it did not exist. Because it is there. It cannot be wished away. And it must say something. It must, at the minimum, say this, that the Constitutional Court of this country, 11 judges, feel that the rescission application is something that is worth to be listened to. And that on the basis of that listening to, if we take the rules aude alteram partem to its logical conclusion, it cannot be that any court says, I will listen to you, but I know that I'm going to find against you. If that is the basis on which those directions are issued, then they would be illegal. Surely, those directions are issued on the basis that this matter is worth hearing and there is a possibility that you may succeed. Otherwise, speaking for myself, I'm not going there. If the idea is just to give a hollow hearing from which there's no possibility of success. And I'm 100% sure, as your lordship would be, that our Constitutional Court would not make such a wasteful exercise and issue directions which would be a waste of paper in that manner. So, if we therefore accept that whatever legal effect the directions have and their existence is something that your lordship must take into account, the fact that before your lordship and before the Constitutional Court, the state parties, let me call them that, are abiding by the, you'll see from the letter that they say they will abide even in the Constitutional Court alone. Is there, it's a fact that your lordship must take into account. But more importantly, my lord, sorry, I thought the lordship looks like it was going to ask me a question. Yeah, no. Can I just finish that thought? Yes, my lord. Yeah. Sorry, my lord, these electronic things are so prone to interruption. No, yes. The fact that the order, or rather the Constitutional Court may find in favor of an applicant in situations where we're dealing with the liberty of a person, my lord. This is not about whether the car is going to remain with me or my learned friend, Mr. Ngokai Toby, or that kind of thing. This is about the liberty of an individual in a democratic constitutional state. And that is why when we say this situation is akin to habeas corpus, we don't say it lightly, my lord. It is exactly the same situation as when you do an application for habeas corpus when the person has already been arrested. And you say, you can come to court, your lordship knows, you can come to your lordship's house at 1 a.m. in the morning for that kind of order without any papers and say, my Lord, I need an order. Why? Because a person's liberty will be at stake. My Lord, your Lordship knows, again, from the provisions of, or rather the commentary that you have around arrest, which is what we are really talking about here. The Lordship would find that comment at 5-1 of Detoy, the commentary on criminal procedure. It says arrest, by definition, constitutes a serious restriction of the individual's freedom of movement and can also affect his dignity and his privacy. That means, my Lord, what you have before you is not just a question of Section 12 or Section 35 of the Constitution. It's also a matter of Section 10 of the Constitution, the right to human dignity. It says, in order to extend the principle that before conviction, an accused person ought to be treated as far as possible as being innocent, it is submitted that arrest should be effected only where it is likely that a summons or written notice to appear would be ineffective. And further down it says, my Lord, if an accused or a suspect does not represent a danger to society,
but we think those provisions are applicable because we're talking about the court order here. There's a court order that needs to be executed. I don't think, to the extent that you're referring me to them, I don't think they're applicable here.
My Lord, an arrest is an arrest, my Lord. With
I
the greatest
understand.
respect. So,
I understand. What I'm trying to say is this, that you get warrant or whatever. In this instance, we have this situation that there is an order that has to be executed.
yes, it's the same as a warrant, my Lord. I'm not addressing your Lordship about warrants. I'm addressing your Lordship about what an arrest is.
Yes. No, I understand that, yeah.
Yes, I'm saying, my Lord, yeah, with the greatest respect, my Lord, when you are arrested and you are locked behind bars, it makes no difference whether you are here as a result of the dignity, all the issues that I've just read out, my Lord, will be affected, whether or not you are arrested as a result of A or B piece of paper.
It's obvious. That's an obvious question. I'm just saying to you, I mean, should we not confine ourselves to the order itself?
No, my Lord. With the greatest respect, okay, unless if we're not going to talk about the context of what that order is about, which is an arrest, because that's really what I'm addressing. I'm saying this is not an order for the exchange of a car between me and Mr. Matobi, my learned friend, and I'm distinguishing it for exactly the reasons that what we have here, the Lordship could say, if this was about a car or a bottle of water or whatever, could say, well, I may be wrong, I may be right, but hey, what? But when you are dealing with what I'm reading to you, my Lord, which is the most egregious invasion of a person's dignity and privacy, then, my Lord, I would not understand why that would be an irrelevant consideration as to what that order that your Lordship is before your Lordship on day one is, as opposed to another one which might be before your Lordship tomorrow about a car or whatever. But I'll then just leave it at this, my Lord, that an arrest is an arrest, but by any other name.
Yes.
And detention without trial is detention without trial. It doesn't matter where it emanates from.
No, I understand all that. I understand all that. Yes.
And by the way, my Lord, that also touches on the issue of Part B, because your Lordship must at all times be aware that there is another application before that court which is about the interpretation of the Criminal Procedure Act. And that interpretation, when that happens, your Lordship has to conceptualize that that theoretically that application was before your Lordship tomorrow, let's say. Now, if that was so, my Lord, your Lordship would be forced, would not be able to escape the fact that in dealing with that matter, the Section 39(2) compels that court, the Part B court, to do the following. When interpreting any legislation that would include the Criminal Procedure Act, so that it's not a matter that is external to what your Lordship is considering. And when developing common law or customary law, every court, including your Lordship, tribunal or forum, must promote the spirit, purpose, and objects of the Bill of Rights. And that includes these issues of dignity, these issues of privacy that I was talking about in those quotations, the issues of deprivation of liberty. So that issue, it might look like it's a separate issue, but it is squarely before your Lordship in the context of Part A, but even more so in the context of Part B. And I must say, even in the context of the matter that is before the Constitutional Court. But I will leave it at that. So what we have therefore, my Lord, is one of, even in the words of the majority judgment, the most unprecedented exercise of judicial power. Unprecedented. Justice Khampepe herself says it is the first time. She says she searched through the annals of all the libraries, and she could not find a situation where a person is taken to direct imprisonment without a trial in proceedings where the applicant, in this case the commission, seeks solely to impose a punishment over that person. Now, if that does not shake anybody's spine, nothing ever will. The first time in this country, and I will dare say in any other democratic country, where a person is being sent to jail without a trial in proceedings where the applicant or the contemnee seeks solely imprisonment. It has never happened under the sun. Maybe in some regimes which don't have constitutions, it happens all the time. Never. And that person, my Lord, who's subjected to that, where the order, the person who originates the order that your Lordship is talking about, says that this is unprecedented. I could not find it anywhere. It's happening for the first time. In a court of last instance, my Lord, of first and last instance, where the right of appeal has been denied. No, my Lord. With the greatest respect, if anybody under those circumstances can say that such a person must, while waiting for that extraordinary order to be set aside, be sitting in jail to satisfy what? The vengeance and the hatred or whatever animosity might be that might emanate from these respondents, the commission, the acting Chief Justice, and the what's it called? Helen Suzman Foundation, probably with an office somewhere and a laptop. So when, my Lord, and hear me out, my Lord, here, just on this, if nothing else. And this goes back to your Lordship's favorite topic of jurisdiction and introduces another arrow to that bow. Remember, my Lord, that in this case, unlike your Lordship will remember, there's a case called Saratoga Avenue. Sorry, my Lord. Yes. Occupiers of Saratoga Avenue versus City of Johannesburg Metropolitan Municipality and another, which is 2012, volume 9, BCLR 951 CC. Oh, sorry, my Lord. This is difficult to manage these kinds of hearings. It was said, okay, let me again start by telling your Lordship where I'm going with this, so that as I develop it. There are situations, my Lord, where the Constitutional Court arrogates to itself the execution of an order. The Lordship knows that. Where it would, when it grants an order in these kinds of situations where evictions and so on, the Constitutional Court appoints itself, so to speak, as the supervisor of an order. Those situations must be contrasted to situations where the Constitutional Court has deliberately and expressly delegated the execution of the order to another agency. Don't know if your Lordship is with me in that distinction. Yes. Now, what do we have here in front of your Lordship? We have, if your Lordship goes to the actual order, that brings us in front of your Lordship. And the Lordship will find it, the convenient part is just the beginning of the judgment, where the order is set out, yes. Paragraph, order number 5. Well, let's start with number 4. That's the arrest, the sentence. Mr. Jacob Zuma is sentenced to undergo 50 months imprisonment. And then number 5 says, very important, my Lord. Mr. Jacob Zuma is ordered to submit himself to the South African Police Service at Nkandla Police Station within your Lordship's jurisdiction, or Johannesburg Central Police Station within, again, the order, the issue of concurrent jurisdiction arises. In other words, we could have brought this in front of your Lordship. We could have also brought it in the Johannesburg High Court. But if we went there, nobody would have said, why did you not go to Maritzburg, as I've said earlier? Or nobody could justifiably say that. Anyway, it says, within 5 calendar days from the date of this order, for the station commander of Nkandla Police Station or other officer in charge of that police station to ensure that he is immediately delivered to a correctional center to commence serving the sentence imposed in paragraph 4. Number 6, in the event that Mr. Jacob Zuma does not submit himself to the South African Police Service, not to the Constitutional Court, as required by paragraph 5, the Minister of Police and the National Commissioner of the South African Police Service must, within 3 days, calendar days of the expiry of that period stipulated, take all steps that are necessary and permissible in law to ensure that Mr. Jacob Zuma is delivered to a correctional center in order to commence serving the sentence imposed in paragraph 4. What does that mean? It means that in this particular instance, the Constitutional Court deliberately, when it had the power to assume the supervisory and execution powers of the order, delegated those powers to the Minister of Police and the National Commissioner. This Constitutional Court of this country, my Lord, knew that the people that it had enlisted here were, before it, the second and third respondents. And that there was somebody else called the Judicial Commission of Inquiry and another somebody else called the Helen Suzman Foundation. It did not delegate to them the power to arrest and detain the former president. Why? Because the institutions that are constitutionally empowered and charged with that responsibility are those to which it indeed did delegate. And those institutions, my Lord, are before you. So the execution of the order is in the hands of those people, including the station commander of the Nkandla police station. And those people are rightfully before your Lordship. Now, why is that important, my Lord? It is important because in the Saratoga case, sorry, man. That distinction was made by Froneman J. at paragraph 12 onwards. So the Constitutional Court said, it is important to remember, however, that the kind of orders or let's start at paragraph 11, my Lord. It says, when a court decides a constitutional matter within its power, section 172(1)(b) of the Constitution allows it to make any order that is just and equitable. I've already addressed that proposition. I'm just quoting that part for emphasis. And then it says, it is important to remember, however, the kind of orders sought to be varied in Zondi and discharged in the residence of Joe Slovo community. These were other cases. In Zondi, a statute had been declared constitutionally invalid, and under the just and equitable remedy provisions of section 172(1)(b), this court had suspended the order of invalidity. In residence of Joe Slovo community, the eviction order made by this court was, quote, coupled with a detailed supervisory order concerning the execution of that order. These were both cases where this court made just and equitable orders that made it clear that the court itself, in other words, the Constitutional Court, chose to regulate and oversee their execution. Unlike the court that is the case that is before you. That is not the case here. That is now paragraph 13. Just as it is not before your Lordship. That is not the case here, and will really be in appeals heard by this court. There is no indication in Blue Moonlight 1 order of any continued oversight by this court. In the absence, this is the punchline, in the absence of a clear indication of this kind, it must be accepted that the order this court makes on appeal becomes the order of the court of first instance, in other words, the High Court. Now, what does that say, my lord? The importance of this, and I know the facts are different, but I'm saying the Constitutional Court made a distinction between those orders which would be supervised by it, which it makes when it wants to, and those orders that must be supervised by other people, which it makes when it wants to. And your lordship is dealing here with that, second type. And for that additional reason, if your lordship just reads the order as it is, which assigns all these people, these players, including the station commander, within the area of jurisdiction of this court, the power to actually effect the actual arrest and or the committal. Because your lordship would know, we all know from experience, that if the station commander of Gaza were to effect the arrest, then of course he would then be committing the person to a correctional service center that is within their own jurisdiction, which again falls into your lordship's jurisdiction. Putting aside the fact that members of the security cluster, such as the Minister of Police, the National Commissioner, and to some extent the President, have found it necessary that the arrest should be put in abeyance. Putting it aside, that, my lord, and this is an important point, my lord, on the experience of this particular case, the urgent relief which was sought in February was only granted in July, end of June, 29th of June, 3 months thereafter. So what your lordship is being asked, and I'm not saying that the next judgment will be 3 months, it might be 2 months or whatever it is. Let's even say 1 month. But what your lordship is being asked to do is that for all that period between now and the hearing, between the hearing and the judgment, 1 month, 2 months, 3 months down the line, the applicant must be sitting in jail without ever having seen any trial. And then only thereafter, if the judgment is set aside, so oops, then he must be released. What is that, my lord? What is that? And it goes, my lord, to the root, with the greatest respect, my lord, of what I called at the beginning of this address, the nature of the relief that is sought before your lordship. And I will refer your lordship, without going there directly, to the case of Piccoli. Piccoli versus President of the Republic of South Africa, 2010, Volume 1, SA, 400 GNP at 403 against the letter I. And your lord, my lord, that is paraphrased the D6-4 of Erasmus as follows. An interlocutory interdict is one which is granted pendente lite. It is a provisional order designed to protect the rights of the complainant party pending an action or application to be brought by him to establish the respective rights of the parties. It does not involve a final determination of the rights of the parties and does not affect such determination. Underline that. It does not involve a final determination of the rights of the parties and does not affect such determination. Its effect is to freeze, quote unquote, the position until the court decides where the right lie, at which point it ceases to operate. It is aimed at ensuring, as far as it is reasonably possible, that the party who is ultimately successful will receive adequate and effective relief. Right? The party who is ultimately successful. In other words, put yourself, with the respect, my lord, in the shoes of this applicant when he is ultimately successful in the rescission application. And ask yourself, my lord, whether he will have received effective and adequate relief if 2 months, 3 months down the line, he would have been sitting in a prison cell. The answer is an obvious no. And that is the nature of the proceedings before your lordship. And that, with the greatest respect, should compel your lordship to find that in this particular matter, based on just and equitable remedy, based on anything, quite frankly, based on just the interests of justice, based on the public interest considerations which must have been taken into account by the non-opposing respondents, based on justice and the operation of the laws on Section 172 and the interim interdict pendiente lite, and based on simple justice, my lord, your lordship has to grant the order asked for, if nothing else, on the basis that Part B before your lordship falls within the exclusive jurisdiction of your lordship, and Part A may or may not fall within the concurrent jurisdiction of your lordship and any other court, which I've said is irrelevant. But more importantly, the fact that that other court happens to be the Constitutional Court does not change the rule set out in Pollack and in the relevant cases, that this court has jurisdiction in respect of the execution of any other court. If that was so, then the judgment in Gambling Board, which says that even when the main action falls within the exclusive jurisdiction of the Constitutional Court, this court would have jurisdiction, would be wrong. And it is not wrong. Well, my lord, that will be the longest unopposed application your lordship has ever had to entertain. But if there's anything else, my lord, we'll address it unless if your lordship has a question, of course.
No, I don't have. Don't have.
My lord,
we must move on, or should we take a short adjournment?
Yes, we are now at 2:30. I feel for everyone who's been sitting through these 2.5 hours. Perhaps we should take an adjournment. I just don't know what would be effective.
About 30 minutes. Is it okay?
30 minutes.
Yeah. If it is okay with you.
I can't. Can I just outline, my lord, what I'm going to do? And
I'm just saying adjournment, the short adjournment, yeah. Just to give,
Yes, no, I'm happy to take an adjournment. I wanted to just tell your lordship what I would do after the 30 minutes.
Okay.
Yes. My lord, what I have 5 themes to address. The 3 themes are on the merits of the argument. In other words, the jurisdiction, the alternative remedy, and what we say is the duty to comply. What I'm going to do, I will spend the first 10 minutes just outlining the key events that are crucial. They are all set out in the answering affidavit, and your lordship need not necessarily go through it now, but simply to note the key event. And then the second point on jurisdiction, what I propose doing is to answer the narrow question, which is, where is the jurisdiction for for the suspension of an order of the Constitutional Court. The argument is there is none, and none of the arguments made by my learned friend actually answer that central proposition. The third point is there is, in fact, an alternative relief, and your lordship knows the law on interdicts. You can dismiss an interdict if there is an effective alternative relief. In this case, it is an approach to the Constitutional Court. And the fourth point is there is, in fact, an ongoing obligation on the part of Mr. Zuma to comply. It is not suspended by his institution of the application for rescission. It is not suspended by his institution of the present application. Since Sunday, Mr. Zuma has been in an ongoing breach of the present order, let alone the order for which he was already convicted, but he has been in breach of the present order. Now, I am not here talking about the conduct of the police in equivocating about the enforcement, but Mr. Zuma on his own has literally taken the law into his own hands. That on its own should be a ground for dismissal. And the last point is around so-called Part B. I've taken your lordship's counsel seriously that we should get too much into the detail of the rescission, because that is a matter that will be heard in days before the Constitutional Court. So I will not be addressing the merits of that rescission, but I will be telling your lordship that you have 3 clear-cut grounds to dismiss the application with costs. So I'm happy now to take the adjournment, and then I'll continue when we return.
Mr. Duplessis, do you want to say something before we adjourn, or should
No,
we?
my lord, it's
My lord,
fine.
I'm happy to adjourn, and I will pick up after Mr. Tube.
Okay, we'll come back at within 30 minutes.
As a courtesy.
Thank you, my lord.
I just wanted to say, my lord, that was not one of my juniors.
Right. Can we carry on? Can we?
It looks like it's sorted, my lord.
I can't hear Mr. Nwaitobi. I can't.
It's muted.
Yeah, it's muted. Yeah.
Sorry,
Now I can hear you. Yes.
Thank you.
Thank you.
Thank you, my lord. Starting then with the first theme, which is the key moments in the narrative. The convenient starting point is the 3rd of December, 2020. That, of course, is when the first application to compel Mr. Zuma to comply with the summons was instituted. What we know about that is that it was served on Mr. Zuma personally. It was also served on his attorney. We also know that Mr. Zuma does not file a notice to oppose. The second key moment is the 14th of December, 2020. On that occasion, the Chief Justice had issued directions calling upon the parties to indicate their position. Mr. Zuma, through his attorney, Mr. Mabuza, files a letter to the Constitutional Court in which he tells them explicitly that Mr. Zuma will not participate at all. The next moment is the 28th of January, 2020. Then the first judgment is granted. It makes it explicit that Mr. Zuma must comply with the summons issued by the Commission. On the 1st of February 2021, which is the fourth moment, Mr. Zuma issues a public statement. In that public statement, he denounces the courts, he denounces the judiciary, he denounces the Constitutional Court itself. On the 15th of January, which is my fifth key moment, Mr. Zuma is expected to appear before the State Capture Commission in accordance with the order granted on the 28th of January 2021. But he does not. But he still has legal representation. Mr. Mabuza tells the Commission that Mr. Zuma will not be appearing at the State Capture Commission. He has some excuses given in the letter, but the bottom line is that Mr. Zuma, via his attorney, is explicit that he will not be appearing. That evening of the 15th of February 2021, Mr. Zuma himself issued a public statement in which he again rages and denounces the Commission. Of course, Justice Zondo had announced that in the light of his non-appearance, contempt of court proceedings would be instituted. The seventh moment is the 22nd of February 2021. In accordance with what the Deputy Chief Justice had said, the contempt of court proceedings were in fact instituted. They are also served personally on Mr. Zuma, also served on his attorney. On the 1st of March 2021, the Chief Justice issues directions which are also served on Mr. Zuma personally. No judgment is given at that point until another event, which is number 8, on the 9th of April 2021. There, the Constitutional Court invites Mr. Zuma to make representations on a possible sanction. Mr. Zuma does not, in fact, make those representations. Instead, on the 14th of April 2021, again in a letter sent undercover from his attorney, he openly rejects the possibility. Where we stand, therefore, is 6 times Mr. Zuma has been invited either by the Commission or by the Constitutional Court to make his representations. 3 times he has personally rejected those invitations and denounced the Constitutional Court publicly and raged at the judges of the Constitutional Court and insulted the institution of the judiciary. On 3 occasions, his defiance is communicated by his attorney, Mr. Eric Mabuza. Most recently, on the 29th of June 2021, the Constitutional Court delivers the present judgment, which is the subject of the rescission application. that judgment makes it clear that he is guilty of contempt. It also makes it clear that he has had more than adequate opportunity to have his say, and instead he has rejected every opportunity, denouncing the judges in the process and sometimes using foul language against them. That judgment, it's important to have regard to the order that it grants. In paragraph 3, it declares Mr. Zuma as being guilty of the crime of contempt. In the application for rescission, he seeks an order rescinding that. But in the application for suspension, which is the application before your lordship, he does not seek an order suspending that conviction. In paragraph 4, he is sentenced to undergo 15 months imprisonment. In paragraph 5, he is instructed to hand himself over. He is required to submit himself to the police. In paragraph 6, if he does not submit himself to the police, then in effect he should be arrested. Where we stand right now, in addition to the conviction that was delivered on the 29th of June, Mr. Zuma has once again not complied with paragraph 5. He has not handed himself over to the police. The date by which he should have handed himself over lapsed on Sunday. He is now 2 days after the lapsing of that period. He has no permission from anyone. He has again taken the law into his own hands. He has not asked for the variation of that period before the Constitutional Court. He did not launch these proceedings prior to the lapse of the order at paragraph 5. So that then is the context in which your lordship approaches this matter. We are dealing with a recalcitrant, deliberately defiant litigant. He is presently in defiance of the present contempt of court. This, of course, is undoubtedly a grave situation. It is a grave matter that there is a litigant who has continuously defined himself outside of the strictures of the law, defined himself outside of the ambit of constitutional authority, and defined himself outside of judicial authority. But grave as it is, our law caters for it. I shall be explaining to your lordship what the legal principles are which should guide your lordship to apply to a case as grave as this is. But first, your lordship should dismiss the application entirely because he is in the wrong court. The argument on jurisdiction is set out in our heads of argument from paragraph 6 to paragraph 15. I've noted at paragraph 7 that we made an error that he did not apply to rescind paragraph 3. It should be he did not apply to suspend paragraph 3, not rescind. He did apply to rescind. Firstly, when one considers the jurisdiction, you must have regard to the nature of the relief that is sought in Part A. My learned friend, almost entirely in his address, spoke of jurisdiction for Part B, which obviously is a mistaken approach to take. The jurisdiction in issue is a jurisdiction for Part A. We don't contest this court's jurisdiction for Part B. We contest the jurisdiction for Part A. If we look at 2.1, what he wants is an order that pending his rescission and pending his Part B, what should happen? You must stay or suspend the execution of the relevant orders. That order is a constitutional court order. In 2.2, he wants an interdict from the execution of the order in 4, 5, 6 of the aforementioned judgment. That is the judgment of the Constitutional Court. The judgment of the Constitutional Court is itself an interdict. It is a mandatory interdict instructing him what to do and instructing the police what to do if he fails to do it. So what we have is an application for a counter mandamus from a lower court, a counter mandamus that will alter the time periods that are mandated by the Constitutional Court. It is a clear conflict between the two. Why then you cannot do this? Firstly, the Constitutional Court is the highest court in the country. We know that as per section 167 of the Constitution. But it is not only the highest court in the country, it is also the final court of appeal. There are no further appeals. When it has exercised the extraordinary power of granting direct access, it does so firstly, but crucially, finally. That means, in plain terms, a court inferior to the Constitutional Court may not interfere with a judgment or order granted by the Constitutional Court. I heard my learned friend placing a lot of emphasis on this phrase, pendente lite. Pendente lite does not mean that if a lower court has the authority to alter a ruling, a judgment, a date contained in a judgment of the Constitutional Court. I had my learned friend also talk about a delegation to functionaries. The functionaries are not delegated, they are instructed, they are mandated, they are under an order to perform services.
In any event, it's part of their duty too.
Precisely,
Yes.
Precisely, my lord, thank you. What my learned friend then relies on is section 173 of the Constitution. Firstly, your lordship already pointed out the anomaly that if one looks at the text of section 173 of the Constitution, the text is inherent power is the heading. The wording is the Constitutional Court, Supreme Court of Appeal, and High Courts have the inherent power to protect and regulate their own process and to develop the common law, taking into account the interests of justice. Your lordship pointed to this own process. So you do have inherent power, but inherent power over your own process, not over the process of the Constitutional Court. What do we know about jurisprudentially this meaning of the section? In our heads of argument, we deal with this from paragraph 11. Firstly, we start with the judgment of the Constitutional Court in Mulawuzi at paragraph 34, judgment of Justice Teron, in which she says, the power in section 173 must be used sparingly. Otherwise, there would be legal uncertainty and potential chaos. In addition, a court cannot use this power to assume jurisdiction that it does not otherwise have. So it is not a jurisdiction granting section, but it is a power regulating section, but the jurisdiction must pre-exist. Crucial distinction, completely overlooked by our learned friends. But there is also an earlier judgment of the Supreme Court of Appeal, which is much more explicit about section 173. It is the Oosthuizen versus RAF judgment. It cites in paragraph 17 an earlier judgment, Nomsa versus Fries Metal, which says that section 173 power does not extend to the assumption of jurisdiction not conferred upon a court by statute. And then Oosthuizen contains this important line at paragraph 18. Section 173 does not give any of the courts mentioned therein, including the High Court, carte blanche to meddle or interfere in the affairs of inferior courts. Remember this, my lord. The Constitutional Court cannot interfere in your own affairs. It can only do so on appeal. Remember this, you, your lordship, cannot interfere with the magistrates' courts in their own processes. You can only do so on appeal. If you cannot interfere with the functioning of an inferior court as the High Court, how much more with a superior court? That passage, paragraph 18 of the Oosthuizen judgment, is then emphasized later, where the judges say, this dictum must be read alongside what has been stated above. A High Court can only act as described in this dictum when it already has jurisdiction over the case. So 3 portions are crucial. This is not a jurisdiction granting case. It is a power regulation, jurisdiction granting section. It is a power regulating section when you already have jurisdiction. Jurisdiction must exist on an anterior basis. Once it exists, you may exercise it. You may not grant yourself the jurisdiction by Section 173. Number 2, Section 173 does not give you authority to interfere with the functioning of the lower courts. And then number 3, as per S versus Mulaudzi, the section ought to be cautiously applied. Otherwise, there will be chaos. It is precisely this type of jurisprudential chaos that we are being invited to do.
That's actually the discomfort that I have.
Yes.
If, for instance, I say I issue this order,
Yes.
what will they say about the Constitutional Court orders?
Yes.
Because this is the apex court.
Yes, exactly. And once it has decided to be first and last, it's an extraordinary power. It has decided that no one else must hear the case, only us. And it has given an explicit order which is unambiguous. Mr. Zuma must go and present himself on Sunday. If he doesn't present himself on Sunday, tomorrow he must be arrested by the police. There is no ambiguity in that order. This is not up to a judge of a lower court. And your lordship would not be able to even interfere even if it had been issued by a judge lower than you. You wouldn't be able to interfere under Section 173. Then our learned friend says, well, I have another argument, Section 172, 1b. But again, let's start with the text. Section 172 says, powers of courts in constitutional matters. When deciding a constitutional matter, here is the key, within its power. Let's repeat that. When deciding a constitutional matter, within its power, a court may make an order that is just and equitable, including, and then it explains. In other words, justice and equity are not jurisdiction conferring attributes. The jurisdiction must pre-exist because the section says if you are making an order within your power, you may have the following powers, the powers of regulation. So if jurisdiction is precluded by virtue of the nature of the order being a constitutional court order and a superior order, therefore, Section 172, 1b is not a jurisdiction granting section. It is the powers you have upon the pre-existing jurisdiction. Then, what are we left with in these arguments? We are left then with the argument that says a high court may, in certain instances where the exclusive jurisdiction of the constitutional court is engaged, issue an order on an interim basis. I found a judgment dealing with something similar to that. It's the United Democratic Movement versus President of the Republic of South Africa and others. It is cited at paragraph 14 of our heads of argument. But it is wholly misplaced because that is not authority for the radical proposition that has been submitted by Mr. Zuma or on behalf of Mr. Zuma that you should suspend the judgment of the Constitutional Court. It simply says you can interdict Parliament because you have judicial authority over them, or you may interdict the legislature, the executive, from bringing into effect legislation that you want to challenge at a later stage, even if that challenge is on an exclusive basis. Say the president is about to release 1,000 prisoners on mercy or parole. Because it is the conduct of the president, only the Constitutional Court may deal with it. You may, in the interim, ask the High Court to interdict the president while you go to the Constitutional Court to challenge it. But it is not authority for the proposition that is being advanced today, which is this court must meddle. And the language of meddling comes from the SCA in Osthuizen versus RAF, must meddle with a judgment and an order of the Constitutional Court. To do so is to invite judicial chaos. Our learned friend is then left with the Pollack on jurisdiction, in which it is said, and my learned friend thankfully read this out for all of us, because it's very unclear from the copies that were circulated, but in which it is said that it does not matter where Part B lies. On Part A, a High Court would be entitled to issue an order. But stating that proposition illustrates precisely why it is completely irrelevant to what we are dealing with here. We are not dealing with who has jurisdiction for Part B. We are dealing with who has jurisdiction in respect of an order granted by the Constitutional Court. More narrowly, we are dealing with whether or not the High Court can suspend a period prescribed by the Constitutional Court. It is not a surprise that my learned friend, in his entire address, never once brought any authority that is on point and argued around the point. So, on those 4 reasons, it is quite plain that there is no jurisdiction to suspend a decision of the Constitutional Court. That jurisdiction belongs to the Constitutional Court. That takes me, my lord, to my next point, which is the issue of an alternative remedy. It is linked to jurisdiction, and I will explain in a second why it is linked to jurisdiction. But it is a separate ground to dismiss this application. Your lordship knows the law. You may dismiss an interdict if there is an available adequate remedy. The remedy that is most obvious is approaching, and you asked my learned friend this question, is approaching the Constitutional Court for a variation. But our learned friends didn't do that. It is clear that the Constitutional Court has jurisdiction to vary its own orders. It has jurisdiction to suspend the enforcement of its own orders. It may do so in accordance with Rule 12 of the Constitutional Court rules, which specifically provide that if you bring an application under that rule as an urgent application, the Chief Justice may dispense with the forms and service provided for. In other words, the matter may be dealt with on an extraordinarily short basis. The Constitutional Court, and we did a full search of the instances where the court has suspended the periods provided for in its orders. We collated those at footnote number 4. We found Nduli, Sibiya, Teddy Bear Clinic, ex parte Minister of Justice and Minister of Social Development. Collated those at footnote 4. I have no doubt that there are others. When you go through those judgments, what you find is instances where the Constitutional Court says, Parliament has 2 years to pass legislation dealing with X. The 2 years is now up, and Parliament has not performed the legislative amendment. They go back to the Constitutional Court and say, guys, we're sorry, we cannot meet the deadline. Please extend the period in the order. And those are the type of examples where the Constitutional Court says, sorry, we will not allow you, or sometimes it says we will allow you. But in all of those judgments, it says we are relying on our power under Section 172(1)(b) or under Section 173. But it's always in the context of a pre-existing jurisdiction. So there is no question that the Constitutional Court has previously engaged with the power of altering the time periods contained in their own orders. And they derive their source, constitutional source, in Section 172(1)(b) and Section 173 of the Constitution. That is, in fact, the correct setting in which those sections may be engaged, not here. In the answering affidavit, Your Lordship pointed this out to my learned friend at paragraph 7, answering affidavit of the of Justice Zondo. We took the point there that the Constitutional Court could be approached because it has the power to vary its own orders. But in addition to that, we invited expressly the applicant to approach the Constitutional Court. You asked him the question also today, and what you have heard is that it was a choice they made. Mr. Zuma simply did not want to be litigating in two forums. So he deliberately chose not to go to the Constitutional Court and to put his eggs in the High Court basket. He must live with that choice, just like he must live with the choice of not opposing the earlier orders of the Constitutional Court. But quite apart from the fact that there is an alternative remedy that is plainly available to Mr. Zuma, there are very strong reasons why Mr. Zuma, in fact, ought to be running this litigation that has occupied us for today before the Constitutional Court. Let me list at least 6 of those reasons. Firstly, the 2 orders that we are dealing with, the January order and the June order, 28 January, 29 June, are orders of the Constitutional Court. Secondly, when the Constitutional Court granted the contempt order, 29 June, it weighed the public interest and it weighed Mr. Zuma's interest. It knew Mr. Zuma's age. It knew the conditions in the prison. It weighed all of those up and decided that he should nevertheless serve 15 years in prison.
15 months.
Sorry, 15 months in prison. Yes, 15 months in prison. 15 years is the mandatory sentence for certain offenses, but this is a contempt. Nevertheless, decided that he should serve 15 months in prison. Thank you, my lord. Number 3, the rescission application is pending before the Constitutional Court. In fact, as Mr. Mpofu correctly points out, the Constitutional Court has elected to hear the case. Now, my learned friend says that they cannot set it down unless they know something about the merits. I would be very skeptical about that. My own experience of the Constitutional Court is that it is impossible to read them upfront, but I may well be wrong. Number 4, when the Constitutional Court set the matter down for the 12th of July, it knew that it had the power mero motu to suspend the execution. It has the power mero motu to suspend the execution. It knew precisely when the order has to be executed. It knew the date the police must arrest Mr. Zuma if he doesn't hand himself over. It knew the date when Mr. Zuma should hand himself over. But despite that knowledge, it decided not to use the mero motu power of suspending the operation. If Mr. Zuma applies to the Constitutional Court, who knows what their view is in the light of the submissions that he would make. But what we know for a fact is that the mero motu power of suspension was not utilized. Number 5, the Constitutional Court also knew that it would be a matter of days between the date of his arrest and the date of the hearing of the 12th of July. There is no way that they didn't know that we are hearing the case 3 days after the date we have ordered his arrest. And that if that was a factor, it would have been ventilated in their own order. And finally, it is manifest that the correct court to run the balancing exercise about harm versus the rule of law considerations, which are quite strong in the judgment of the Constitutional Court, is the Constitutional Court. The matter is before it. It is engaging with that matter on an expedited basis. Mr. Mpofu is right when he points out that they granted directions on a Saturday when they could have granted those directions on a Monday. But that's precisely the point. They are engaged with the matter on an expedited basis. And if Mr. Zuma wanted, he would have gone to the Constitutional Court and asked them for the extension or the removal of the period by which he should comply. So it would be wrong for this court to interpose itself midstream. The proper place for these discussions, interesting as they may be, is the Constitutional Court. If it decides that in the interim, its order, which it granted being conscious of the absence of mitigating factors, if it believes that its order should somehow be temporarily suspended by 2 days, by 3 days, by a month, by 2 months, it should make that determination itself. There is no reason why your lordship should now be invited, as it were, to catch the bus midstream. Mr. Zuma always knew about the possibility, Mr. Mpofu did not dispute that, always knew about the possibility, as your lordship pointed out, of accompanying the rescission application with an interdict to stay. He knew about that. He decided not to do it. He always knew that when he went to the High Court, there was a risk that there would be a jurisdictional objection taken, if not by us, certainly by the court. Because when he came to the High Court, he knew that he would be asking for the suspension or the interruption of a judgment of the Constitutional Court. So he cannot complain if your lordship dismisses the application on the basis that there is no jurisdiction. He still has today, he still has tomorrow to approach the Constitutional Court for the stay or the suspension. He can do it even by way of a letter. He has many, many alternatives. But the bottom line is, even on Mr. Mpofu's argument, he accepts that the Constitutional Court is an alternative remedy. He simply explains that for them, they didn't consider it prudent for reasons of judicial economy and for other reasons. That may be so. The fact remains that the Constitutional Court remains not only an available alternative, but an appropriate alternative, because you should not be invited to interpose yourself midstream in the processes of the Constitutional Court. So it should be clear by now, my lord, that you should dismiss the application because you have no jurisdiction. It should also be clear that you should dismiss the application because the interests of justice require you to dismiss it in the light of the availability of alternative remedies, which Mr. Zuma has consciously elected not to utilize. The third point I want to emphasize, which is also a ground for dismissal, is contained at page 9 to 13 of our heads of argument. What I want to say about this, my lord, is to link it back to the way I started my address by highlighting the key events of this case. Mr. Zuma remains under a duty to comply with a court order. And this is not an order issued by the Magistrates Court. Even if it had been, he would be under a duty to comply. But highlighting the seriousness of the situation is he is required to comply with an order of the Constitutional Court. It places a direct obligation on him and only in the alternative on the police. The institution of the rescission application, we've pointed out that at paragraph 24, and my learned friend spoke a lot about Rule 45 capital A. But that Rule 45 capital A is not a jurisdiction granting rule. It presupposes the existence of jurisdiction and then regulates your power to suspend any order. But the important point is what was said by Justice Meyer in the Gauteng division in the case of erstwhile tenants of Willerton Court and another versus Luray Investments, where he makes it explicitly clear that a judgment and an order are not suspended merely on account of the institution of a rescission application. It remains operative. And he does so in the context of Section 18, and he draws a comparison between Section 18 of the Superior Courts Act and Rule 45 capital A. And then he says, you must comply. You may get an order to stay, but you must comply. There is no automatic suspension simply because you have instituted a rescission application. That also puts paid to the nonsensical letter from the police, which is asking the Constitutional Court for clarity. There is no clarity required from the Constitutional Court. The order is manifest. All it needs to be done is to be enforced. Unless the police themselves obtain an order stopping themselves from executing, But at this point in time, we cannot be too critical of the police because their deadline lapses tomorrow. So the order remains operative. Mr. Zuma refused, and it's clear that it is a deliberate refusal. It was not an error or a mistake on his part. It was a deliberate refusal that he did not hand himself to the police on Sunday. He just did not do it. And as the Helen Suzman Foundation points out in its answering affidavit, he actually gave a public statement in which he denounced the idea of his arrest. So we are, in fact, in a situation as grave as that we have a person who has explicitly told the public that he will just not go. The law, on the other hand, is clear-cut. The fact that you've instituted a rescission application, the fact that it has been accepted for a hearing, is not a guarantee that you should not comply. But there are also good reasons why you should dismiss the application so that the judgment can be enforced. And it is set out in the Mulawuzi judgment that we've cited for other reasons. And this is where Justice Theron again speaks. The rule of law and legal certainty, and she is talking here in the context of rescissions. The rule of law and legal certainty will be compromised if the finality of a court order is in doubt and can be revisited in a substantive way. The administration of justice will also be adversely affected if parties are free to continuously approach courts on multiple occasions in the same matter. Imagine then, if parties are free to choose which orders they want to comply, choose which orders they do not want to comply. I'll comply if it favors me, but I won't if it doesn't favor me. Imagine then the implications for the rule of law, most of which are carefully taken into account in the judgment by Justice Khampempe. So we know as a matter of law that your institution of a rescission has no impact on the operability of the order. It remains binding. He should have gone, he didn't go. It also remains binding, by the way, to the police, notwithstanding the fact that they have not received a response from the Constitutional Court. They remain bound by the order. The second part here, my lord, is the pending interdict. In other words, the interdict he has instituted before you also has no impact on his compliance. We know from the order that I began with that Mr. Zuma has separate obligations to the police. His obligation is to hand himself over. But if he fails to hand himself over, the police should arrest him. The legal position on institution of interdict applications is contained in the judgment of City of Tshwane Metropolitan Municipality versus AfriForum and another at paragraph 29 of our heads of argument. And here is the Chief Justice writing on behalf of a majority judgment of the Constitutional Court. He makes the point categorical. He says, it needs to be stated categorically that no aspect of our law requires of any entity or person to desist from implementing an apparently lawful decision. Now, my lord, you must remember, that's a decision, not even a court order. It is a decision, an administrative decision, simply because an application that might even be dismissed has been launched to hopefully stall that implementation. Any decision to that effect lacks a sound jurisprudential basis and is not part of our law. It is a restraining order itself, as opposed to the sheer hope or fear of one being granted that can in law restrain. To suggest otherwise reduces the actual grant of an interdict to a superfluity. We relied earlier to the Mayor judgment in which it is stated that if one can have a scenario where the mere institution of a rescission application is sufficient to stall the enforcement, that would create an undesirable atmosphere because of what he described as unmeritorious rescission applications. It's not that I'm saying the current rescission is unmeritorious. I am simply saying that the reason why the law must be that your rescission does not suspend is to guard against scenarios where you stall the enforcement of judicial determination that are binding on account of rescission applications, no matter how unmeritorious those rescission applications may be. So we say here, Mr. Zuma was never entitled to refuse to submit himself to the police. Submitting himself would not disentitle him to pursue his rescission application or any bail application in terms of the Criminal Procedure Act 51 of 1977. But he has refused to do so. His refusal is a further example of an aggravated contempt. We say, furthermore, that the reason why your lordship needs to follow the approach in City of Tshwane and follow the approach in the judgment by Justice Meyer is because also of Section 165 of the Constitution. The lordship might want to be reminded that Section 165(3) of the Constitution says the following: no person or organ of state may interfere with the functioning of the courts. So it says no person and no organ of state. In other words, Mr. Zuma and indeed the police may not interfere with the functioning of the courts. If the court says something must be done by Sunday, it must be done. If they say it must be done by Wednesday, it must be done. We say Mr. Zuma's deliberate refusal to submit himself to the police in terms of the constitutional court order is an interference with the functioning of the court. If court orders can be disobeyed at will and without consequences, the Constitution will be reduced into a mere paper tiger. Moreover, Section 165 sub 5 says an order or decision issued by a court binds all persons to whom and organs of state to which it applies. It's crucial to remember it's persons to whom and organs of state to which it applies. The judgment we have here applies to Mr. Zuma, and it applies to the police and the Department of Correctional Services. It is binding on them under Section 165 sub 5. They may not, by their own election, decide that it is not binding until they get a letter from the acting Chief Justice. By his conduct, Mr. Zuma has placed himself above judicial authority. He has defied the Constitution. What your lordship should do about a person who has acted in a way that demonstrates that he is above judicial authority, in a way that demonstrates that he defies the Constitution. Your lordship dismisses the application on account of the fact that there is an order that remains unfulfilled deliberately by him. So, my lord, you then have three clear-cut reasons why you should dismiss the application. It is not necessary to go into how genuine or how bad the grounds for rescission. We will be having that debate on Monday, on the 12th of July, before the Constitutional Court. It is not necessary for your lordship to consider how genuine the Part B, which is a challenge to the Criminal Procedure Act. What your lordship will be satisfied by is that the debate as to whether or not a trial procedure or an application procedure should be followed in the context of sorry, my lord.
I was just going to say, in respect of Part B, to a certain extent, the Constitutional Court has already spoken on that. Yes. In Machapeng, I think.
Yes, precisely. My lord, yes. Not only in Machapeng, your lordship is right on Machapeng, but your lordship is also right. The Supreme Court of Appeal has also spoken. Okay. In fact, there are three judgments. It's S versus Mamabolo, which was the first time.
The Mamabolo, that was the first one, yes.
Yes, and then there was a judgment of the Supreme Court of Appeal in Faki NO versus Systems. Yes, and then the last one is Machapeng.
Which crystallized all the judgments.
Crystallizes all of the judgments, yes. But it makes it absolutely abundantly clear that the motion procedure is acceptable as a mechanism of securing a conviction and as a mechanism of imposing a sentence. So you can take that into consideration and simply come to the conclusion that this challenge to the Criminal Procedure Act is a hopeless challenge. So, my lord, where are we with this case right now? I want to say three final things about where we are. We are dealing with a repetitive, recalcitrant lawbreaker in the form of Mr. Zuma. He has now come to ask you to assist him in breaking the law further. You should reject that. 2, we have a strange scenario in which your lordship has been asked to suspend the order of a superior court. Again, you should reject that. 3, we have another situation where Mr. Zuma has continued his law-breaking attitude, now apparently also drawing some inspiration from the conduct of the police. But your lordship should pay no heed to that. In situations as difficult as the current situations, Mr. Mpofu spoke about security concerns, but it's precisely in situations such as this that the law needs to be expressed clearly. The law needs to be pronounced without ambiguity. It's precisely in situations such as this that the judiciary needs to speak without ambivalence about the correct legal position. Today, the correct legal position couldn't be clearer. If we were not dealing with a case such as this that is fraught with external elements, it would be very clear from the outset what the correct thing is, which is to dismiss the current application. So these external features of the case cannot in any way, I'm talking only about the threat of violence, which is hinted in the replying affidavit. That's the only external feature I'm referring to, which is hinted in the papers, and the fact that the police have taken into account a security assessment. Those should not detain us, nor should they dictate what the correct legal position ought to be. So, Your Lordship, we respectfully ask you dismiss the application and order Mr. Zuma to pay costs. Thank you, my Lord. I have nothing else to say.
Thank you. Thank you very much, Mr. Duplessis. Sorry, Duplessis. I'm sorry.
Not at all. Thank you, my Lord.
Yes.
I'm often confused with the journalist.
Sorry.
My Lord, we all know why we are here. And
yes.
While the storm around Mr. Zuma's defiance swirls around this courtroom, my Lord, inside this room, the law is fortunately clear. And we say it leads to ineluctable conclusions. And in our address, my Lord, we seek to stress not 3 themes or any themes, but 3 mountains, my Lord, which we say are insuperable mountains that Mr. Zuma must cross to get his relief. And the first mountain, my Lord, is that this court cannot interdict the Constitutional Court's committal order. And we'll supplement what our learned.
Hello, Mr. Duplessis. I think there's a problem. This is frozen.
Can I call him?
Yes, please just call. We're trying to see whether, please, that I'll appreciate that.
Thank you. Thank you. Max, you are frozen, so just fix that.
Please tell him, I don't know, as far as I can see everybody. Okay.
Yes.
Hello, my Lord.
Yes, I can hear you now. Yes.
I'm back. So all it took was a call from Mr. Nkatube. My Lord, sir, I spoke about the first mountain. The second mountain we say that Mr. Zuma must cross is that even if he could somehow encourage this court to think itself competent to second guess, my Lord, what the Constitutional Court has found and ordered, Mr. Zuma has, through his own multiple and ongoing and deliberate contumacy, disentitled himself from claiming relief from my Lord, and will reference the Constitutional Court authority in that regard, my Lord, which we say is helpful. And the third mountain, my Lord, is we say that there's no prospect that he will succeed in his rescission application. We've heard that my Lord does not want to go into the depth of that, But it is important at least to highlight, we say, certain, what we would call critical features which suggest that there's simply no hope for that application, because my Lord will want to weigh that in deciding whether you would wish to in any way extend some form of extravagant jurisdiction in Mr. Zuma's favour. My Lord, so we will show that Mr. Zuma does not get close to crossing any of those mountains. But before we get to the mountains, we've heard our learned friend for Mr. Zuma, my Lord, and we believe it's important, and we respectfully submit so, to clear the air of two misconceptions. The first misconception arises, my Lord, from Mr. Zuma's legal team trying to recast him as a victim of the Constitutional Court. And we've heard repeated references by Mr. Mpofu, our learned friend, to Mr. Zuma's dignity and his liberty, and the need for habeas corpus, and so on, Lord. But Mr. Zuma is no victim. This case is about past and ongoing defiance of the rule of law through repeated constitutional deviance. And that's been exemplified throughout, my Lord, by Mr. Zuma's deliberate election. So not to appear before the Commission and not to argue, and of course not to comply with the court's orders. My Lord, we say in a calculated show of that deviance, Mr. Zuma deliberately took a step over a line that he knew he could not cross. And as my Lord said in engaging our learned friend, Mr. Mpofu, he said that, my Lord said, the issue here is not an arrest warrant. The issue here is an order. Yes. And so Mr. Zuma has left the Constitutional Court with no choice but to deal with him as a man guilty of contempt. So the Constitutional Court did not make Mr. Zuma's prison bed, my Lord. Mr. Zuma made his own prison bed. And after carefully weighing his dignity and his liberty, the court ordered that he must now lie in it. So that first misconception, my Lord, is important to clear. The second misconception is briefly this, and that is that in some way Mr. Zuma is entitled to special treatment by our courts or by this court. And that particularly, my Lord, we saw through our learned friend Mr. Mpofu's reference to the minority judgment and the suggestion incautiously made with respect that the Constitutional Court missed the wood for the trees. Well, my Lord, we said that would be a mistake too. The Constitutional Court has already, in Commission versus Zuma, my Lord, in its January judgment, criticized the Commission for treating Mr. Zuma differently and with a measure of deference, despite the constitutional injunction of equal protection and benefit of the law. My Lord, that was in paragraph 58 of the court's judgment. And we say this must, a fortiori, be of even greater moment in this case. Mr. Zuma, like everyone else, is subject equally to the laws of contempt of court. And section 165(5) says that, of course, an order or a decision issued by a court binds all persons to whom it applies, including, of course, Mr. Zuma. So that's patently what's required by equality before the law, my Lord. So an order by the Constitutional Court declaring Mr. Zuma guilty of contempt is issued. It confirms the venerable point that while many are high, the law is yet higher. So we've now cleared away that second misconception too, my Lord, that somehow Mr. Zuma may come to this court for special treatment and that he may enlist this court's help in respect of challenging the highest court's orders. Lord, this court knows that the Constitutional Court has, through a majority decision, already finally determined that Mr. Zuma's rights can be constitutionally limited by committal to prison. So the woods are, in the form of the majority judgment, the woods, my Lord, are what bind. It's not the two trees of the minority judgment. So let me then get to the three mountains, we say, my Lord, which are insuperably high and that Mr. Zuma doesn't get across. The first, my Lord, is this. The relief being asked from my Lord is truly the most exceptional relief that we can think of. The request is that my Lord will interdict an order of the Constitutional Court. So, my Lord, even assuming that this court had any jurisdiction to do so, we agree with Mr. Nklatuba, there's no such jurisdiction because of the exceptional nature of what's being asked. That in any event, this court would not exercise any competence or power to perform that form of interdictory action. If Mr. Zuma wants to undo the Constitutional Court's order, my Lord, then he must go to that court, and he knows this. That's why he issued the rescission application in the Constitutional Court. And my Lord asked the critical question of Mr. Mpofu, when you got the directions from the Constitutional Court, why did you not go there? And Mr. Mpofu said, our learned friend said, well, you can't ask the Constitutional Court to suspend. I think that was his immediate answer. And of course, the oddity is, if that's so, if that's what he believes, well, then clearly you couldn't ask the High Court to do so either. And we say the only place that this can take place is before the High Court. And the issues are really fatally against Mr. Zuma in this regard, my Lord. The case in this respect before my Lord asks a fundamentally different role of my Lord than the pendente lite authorities that our learned friend has referenced. He has referenced all of those authorities, my Lord. He has not referenced a single authority where a High Court has effectively interdicted the order of a constitutional court. So while Mr. Zuma simply presents the case as an interim leave case pending rescission, he fails to deal, my Lord, with the most critical feature of this case, and that is that the constitutional court order already exists and is binding. It's that order, my Lord, that is being interdicted so as to destroy, not preserve, the status quo in the interim. Our learned friend, Mr. Mpofu, says that interim interdicts pendente lite are to ensure that the status quo is preserved. And our learned friend said the status quo here, his words were, that Mr. Zuma gets to stay at home. Well, with respect, my Lord, that's entirely wrong. The status quo, by virtue of the Constitutional Court's binding and final order, is that Mr. Zuma gets to stay in prison. And the efforts by our learned friends to come before my Lord is to undo that status quo. So that in that context, my Lord, it is perfectly correct when my Lord said, well, you can't really separate out the warrant and the order. The warrant is the form by which the order is given effect. But it's the substance, my Lord. Our learned friend said, well, one mustn't put form over substance. Well, that's precisely what he's done with respect, my Lord, because the substance here is the order and the form is the warrant. My Lord, in that respect, it's important again to be reminded of exactly what the order is that's being sought. My Lord is being asked in the notice of motion to do the most incredibly extravagant form of intervention. It's, as my Lord knows, at paragraph 2.1, the order that is sought is the staying and or suspending the execution of the relevant orders, pending the outcome of the application for an order of reconsideration. But then, my Lord, interdicting the first and second respondents from executing the orders. Which orders? The orders in paragraphs 4, 5, and 6 of the judgment, my Lord. There is a direct request for my Lord to put a stop to what the Constitutional Court has directed by way of a mandatory interdict. And my Lord, importantly, that interdict, if one goes to paragraph 2, that interdicting of those respondents, my Lord, is not only in respect of the outcome of the rescission application, which is before the Constitutional Court, it's also, my Lord, pending the due determination of the orders in Part B of this notice of motion. So the interim relief that is being sought, my Lord, it's not only in respect of what's coming up before the Constitutional Court on the 12th of July. It is until the determination of the orders sought in Part B. So not only is it an extravagant intervention in the Constitutional Court's order, it is an untold amount of time that intervention is expected to run, because one, of course, doesn't know how long that Part B application will take to be finally determined.
In any event, there is no agency in respect of Part B of the order. There's just absolutely no agency.
None whatsoever, my Lord. But we simply commend, my Lord, the question, what is it that is in fact being asked of my Lord? And it is to interfere with the highest court's order. Our learned friend, Mr. Mpofu, sought to suggest something about the fact that the order delegates the Constitutional Court's power to the Minister of Police. With respect, my Lord, that really is to place an untold amount of weight on the word delegation. It's not a delegation. It is a mandatory interdict. And the Constitutional Court was very clear about that interdict. It said, you must, Mr. Zuma, hand yourself over. And it built into that order a safety net. Recognizing that he might not do so, the court said, if you don't hand yourself over by what was Sunday past, then the Minister of Police must ensure that you're arrested. So, my Lord, it's inappropriate with respect to litigate in this court to ask a High Court judge to interdict an order of the Constitutional Court. If I might just briefly give for my Lord 3 reasons why we say that is so, and they're based on first principles. The first of these principles, my lord, is that the order issued, as we know, from the Constitutional Court, but it issued as an exercise of that court's original jurisdiction. And that's critical. It was that court's protection of its dignity and the public interest. My lord, remembering, the case was brought by direct access. The court could have declined and said, no, go away first to the High Court. It didn't. It said this case is so important, we're going to do the exceptional thing of asserting our original jurisdiction under the Constitution to take hold of it. And then obviously it did so recognizing that it needed to grant an order against Mr. Zuma to appear at the Commission. And then when he failed to comply with that order, it decided again in the exercise of its original jurisdiction to hear the question of whether Mr. Zuma should be committed to prison for contempt of court. All of that, my lord, is an original jurisdictional exercise. We've highlighted in our heads of argument at paragraphs 20, 21, and 22, my lord, that in a case where the Constitutional Court has done so, the High Court has no powers of intervention or suspension in relation to a Constitutional Court order, because the order is not deemed to be one of the High Court's orders which it can interfere with. It's only the Constitutional Court in its own competence that can do so, and in the exceptional circumstances that it must decide exist for it to do so. And that is clear enough from the Constitutional Court's own judgment in this case, my lord, which we've quoted for you at paragraph 22 of our heads. We've said, the Constitutional Court in its judgment firmly stressed that the Constitution itself has taken away the right of appeal where direct access is warranted, that direct access was warranted in this case, and that the Constitutional Court order was, of course, aimed at protecting the integrity of the judicial process through the dignity of the Constitutional Court itself. So, my lord, in that context, we then say, sorry, my lord, have I broken?
No, that is fine. Now you're okay now.
My lord, so in that context, we then turn to occupiers of Saratoga Avenue, and we've quoted it in our heads at paragraph 23. And our learned friend, Mr. Mpofu, also referenced this case. He referenced the paragraphs later, my lord, where he attempted to make the point that it is applicable for a High Court or appropriate for a High Court to be able to issue a suspension order. Well, my lord, what he missed were the earlier paragraphs in the judgment, which we've cited in our heads, paragraphs 7 and 8, where the Constitutional Court made it clear that it's usual that in a successful appeal, the appellate court may make the order that the court of first instance should have made. That order then becomes the order of the court of first instance. My lord, if I'd ask you to just underline the order of the court of first instance. The court then says, execution and enforcement of the order should then take place in that court. Well, my lord, we're in that court in the sense that it's the Constitutional Court as the court of first instance that issued through its original jurisdiction the orders that it did. Not as an appeal court, but as a court of first and final instance. And in those circumstances, my lord, it's the Constitutional Court that must deal with execution and enforcement of its orders. So the position we say is certain, we say there's no room for debate, my lord. This court has no jurisdiction to interfere with that order. It's been asked to do so, we stress, my lord, in the most exceptional of circumstances which we can think of. As I've said, we could find no authority, and none has been referred to the court by Mr. Mpofu, which deals with the situation where post a final order of the highest court, a lower court is asked to interdict that order's effective enforcement, my lord. And so what's left of our learned friend's argument in that respect is a reference to section 172 of the Constitution. And Mr. Nkatube has already dealt with that point in some respects, my lord. We just wish to add the following 2 points. Lord, it's true, as Mr. Nkatube says, that under section 172, all of the powers that Mr. Mpofu is sought to invoke are powers limited by the fact that it's when a court is deciding a constitutional matter within its power. And Mr. Nkatube quite correctly with respect said it's not within this court's power to interdict a constitutional court order. But my lord, there's a further internal modifier in section 172. Internal to section 172, my lord, and my lord knows the paragraph well, is that the court may order a just and equitable order. Lord, the Constitutional Court has already held that the constitutionally appropriate order in this case, under section 172, is immediate committal of Mr. Zuma to prison. So it could never be, with respect for this court, to find that it is somehow constitutionally inappropriate for that to happen, such that this court can then interdict the court's order to the opposite effect. And my lord, just for good measure, our learned friend Mr. Mpofu kept speaking about the EFF judgment, which deals with suspension of executive action, and it doesn't deal with the question of the suspension of a constitutional court committal order. Not surprisingly, my lord, because no such case has ever been brought. Nobody's been bold enough to think of such a case, my lord. So in short, if Mr. Zuma wants to suspend the constitutional court's order, then that court must do it. And nowhere in his papers does Mr. Zuma ever explain, my lord, why he comes here to my lord rather than to the constitutional court. We heard something from Mr. Mpofu from the bar about it's difficult and he didn't know about his prospects. But with respect, my lord, he needed to explain properly why it was that he had abjured his opportunity to, in the same rescission application to the Constitutional Court, ask that court to stay its order. He doesn't explain it, my lord. One suspects it's because he knows that by his repeated contumacy, his chances before the Constitutional Court, my lord, on this score are vanishingly thin. And so he hopes, with respect, to have more success with my lord. But we submit that this court should tell him firmly and rapidly that he has climbed the wrong mountain, my lord. If he wants to suspend, stay, or in other way effectively undermine the court's order in the Constitutional Court, the mountain to climb is in Braamfontein. My lord, there's a second point, very briefly, of principle. Superior orders bind, my lord. Superior orders bind. And Mr. Mpofu, our learned friend, said, context in law is everything. And he also said, my lord, that there's the once and for all rule, which he tried to invoke. Well, precisely, my lord. The Constitutional Court is the contextual feature that he has not faced up to. And it has ruled finally and definitively, once and for all, my lord, as a court of first and final instance, that Mr. Zuma must be committed to prison. And it's right. Within the hierarchy of our system of courts, my lord is bound by that decision. My lord, thirdly, section 165(5) tells my lord all that the Constitution needs to tell you about what to do here, my lord. The Constitutional Court cannot, sorry, my lord, this court cannot suspend or undo the Constitutional Court's order because it is bound alongside Mr. Zuma by the command in section 165(5) of the Constitution, my lord. Orders and decisions issued by a court bind all persons to whom and organs of state to which they apply. And my lord knows that no person or organ of state may interfere in any manner with the functioning of the courts. So my lord cannot be enlisted by Mr. Zuma. And my lord, with the greatest respect, cannot allow himself to be enlisted in order to interfere with the Constitutional Court's order. That would be contrary to 165(5) of the Constitution. My lord, so in conclusion on this point, seen in the correct light, the Constitutional Court has decided to exercise its formidable direct access power, reserved for the truly exceptional cases. It's not open to Mr. Zuma to suggest that a lower court can thwart our highest court's will. And if the main case was sufficiently important to be entertained directly by the Constitutional Court, my lord, then the question of suspension is likewise one that only that court can address. Mountain number 2, my lord. Mr. Zuma comes to this court for assistance, but is in continued contempt. So, my lord, in short, while the constitutional deviance continues, it's an affront to the rule of law that he seeks to enlist your aid, to protect him from his own choices. That was a clear election by him. The Constitutional Court ordered that he had to hand himself over to the police and to be taken into custody by this past Sunday. He refused, my lord. Here too the law is clear. You may not invoke the assistance of a court until you have purged your contempt. Or, putting it differently, as the Constitutional Court has said, a court may refuse to exercise its discretion in your favor for that reason alone, my lord. And the authority we have cited is in our heads at paragraph 31. It's the Constitutional Court's decision in SS versus VVS. My lord might not have had a chance to look at the case, but if I might just say, my lord, in that case, it was a maintenance matter, and an order of court had been issued against the applicant in a matrimonial matter, my lord, for execution of his property. He hadn't complied with the order, and he sought to come ultimately to the Constitutional Court for assistance, my lord. My lord, we have quoted in our heads at paragraph 31 the particular paragraph that is paragraph 31, as it turns out, as well in the Constitutional Court's decision, my Lord. But if I might just read the lines just before the quote that you see in our heads, my Lord, because it's important. The court said, such a sanction, which may at first sight appear to run counter to the right of access to courts enshrined in section 34 of the Constitution, is in my view wholly appropriate in circumstances when one is dealing with conduct that may be described as contemptuous of the authority of the order issued by a court. So the court recognized that this might be regarded as something which is seen as a form of violation of somebody's access to court, but nonetheless, said the court, it is only to be described as unconscionable when a party seeks to invoke the authority and protection of this court to assert and protect a right it has, but in the same breath is contemptuous of that very same authority in the manner in which it fails and refuses to honor and comply with the obligations issued in terms of a court order. The court went on, my Lord, at paragraph 34 to say, under the circumstances and for these reasons, I conclude on what is before us, and that is that there's no evidence that the applicant had remedied his conduct, my Lord, of not complying with the order. This conclusion, said the court, then leads to the question as to whether the interests of justice are served by allowing the applicant to ventilate his argument in respect to the merits of the appeal. And said the court at paragraph 35, those interests will not be best served and will be undermined if the applicant is allowed to proceed and deal with the merits of the appeal in the absence of him remedying his conduct by complying with the August order. These are important words in the next sentence, my Lord. The court said it will dilute the potency of the judicial authority and it will send a chilling message to litigants that orders of court may well be ignored with no consequence. Lord, so the Constitutional Court in that case refused leave to appeal because it said it wasn't in the interests of justice for a Tihera matter where the litigant before it had not yet purged its contempt. And we say with respect, my Lord, this court must turn its face against Mr. Zuma's efforts to enlist this court's aid, to undermine a court order that has already found him in contempt. And it must do so with steely constitutional conviction, my Lord, by discharging its duty under Section 165, to respect the integrity of the courts. And we say, with respect, of course, my Lord, that it is a heightened obligation to do so where his contumacy is continuing. He was, my Lord, in terms of paragraph 5 of the 29 June order, already meant to hand himself over to the police, as we've said. He didn't do so, my Lord. It's on strident display, furthermore, my Lord, that to this day, and now confirmed by in his reply that was filed out of time last night, my Lord, that he is not going to comply. And my Lord, we've set this out in our heads of argument in paragraph 37. And if I might just briefly take my Lord to it. It's at page 13 of the heads, my Lord. We've said, Mr. Zuma remains stridently defiant to this day. He has no intention to abide by the CC order, nor does he intend to appear before the Commission. In fact, his position publicly stated, and my Lord now confirmed before my Lord on affidavit, because the replying affidavit was filed and confirms the Citizen newspaper article that the Helen Suzman Foundation had put up. In that regard, my Lord, his position now publicly stated is that there should be no investigation into corruption at all. In that Citizen newspaper, my Lord, as I said, the remarks that I will read to you next, Mr. Zuma has confirmed that he made. He defends his right to make them, he says, as the basis of freedom of expression. But the remarks, and you just need to read the first two, my Lord. He says, it will be difficult for me to hand myself over for imprisonment when I've done nothing wrong. And secondly, this to me is a clear indication that lawmakers, and even maybe those that are in power, do not have an idea of what it means to be in power and to be in charge of taking care of the laws, my Lord. Just those two statements alone, my Lord, confirm for you the nature of the continuing contumacy. So, my Lord, in that respect, we say the consequence, in the words of the Constitutional Court in the SS case, is that it is unconscionable for him to seek my Lord's protection. His application falls to be dismissed on that basis alone. And again, my Lord, that's because through his own conduct and self-help, he has disentitled himself from the law's protection. My Lord, then the third mountain, and I can briefly deal with it. We say his rescission application is fatally defective. There's no hope, my Lord, for his rescission application And Mr. Nkatuba has already explained why, and we've set it out in great detail in our heads, my Lord, from paragraph 43 onwards, and I won't take my Lord through it. It's enough for me to stress just 2 points, if I may, in underlining just how high this mountain is that Mr. Zuma must climb. And we say that he doesn't get out of base camp. The first reason, my Lord, is that he's perempted his right to seek rescission. We've set out the law on rescission in our heads, and we commend to my Lord the case of Nkata. It's a judgment of his Lordship, Mr. Rogers, in which he stressed that the rule, my Lord, on preemption of appeals, and my Lord knows it well, can't blow hot and cold, that those rules apply to rescissions as well. And to apply the words of Rogers J, my Lord, in that judgment, obviously mutatis mutandis, Mr. Zuma's conduct in refusing to recognize the Constitutional Court's jurisdiction and repeated refusal to participate before it is entirely inconsistent with the continued intention on his part to have the case reopened by way of rescission. Mr. Nkatuba has already, in his opening comments, my Lord, taken you through all of the facts which show where he has repeatedly denounced and refused to appear before that court or to participate in it. And so, my Lord, we say that he has taken those decisions very clearly. He's expressly understood them. And, my Lord, he has stressed, as we have highlighted in our heads at paragraph 51, he has stressed, and he has done so with great public fanfare, my Lord, and he's done so unequivocally, that he is washing his hands of this matter, that he has stated that he has left the matter for the Constitutional Court to deal with. That's when he refused to appear before it, my Lord, and he accepted that this stance may have consequences. That's quoted for, my Lord, in our heads, arising from the 21-page letter that Mr. Zuma sent to the court when it had asked him to make submissions around possible sentence if you were to be convicted. So, my Lord, in short, having blown cold air at the Constitutional Court by refusing to participate, he cannot now try and blow hot air in trying to rescind. My Lord, the second point, very briefly, as to why Mr. Zuma doesn't get out of base camp, is that he palpably fails to meet the requirements for rescission. His application has no prospects of success. I'm not going to go into that, my Lord. I took my Lord's cue from the debate earlier, but I'd simply commend to my Lord paragraphs 58 and 59 in particular of our heads of argument, my Lord. And we would therefore, on the basis of what we've said there, my Lord, which my Lord will read no doubt later this afternoon and into the evening, that his rescission application is adventurous, my Lord, to put it mildly. But this third mountain before him is, we say, unscalable. It has no prospects at all of him climbing it. So if I might conclude, my Lord, very briefly in summary, this court cannot come to Mr. Zuma's aid. There's a binding order and the decision of the Constitutional Court, which the court, my Lord's court, has no competence to subvert. In any event, Mr. Zuma has got no reasonable prospects of succeeding in his rescission application. And as I've said, my Lord, his contumacy continuing to this day means that my Lord must decline to assist him. But my Lord, even if all of those hurdles could be overcome, this court, in the public interest and to ensure the proper administration of justice, should refuse to exercise its discretion to grant the interim relief sought, my Lord. And we say that in reliance on the decision of His Lordship, Mr. Justice Saldanha J, in the Public Protector versus the Speaker of the National Assembly case, my Lord. It's in our heads. We've quoted it at paragraph 99 of our heads, my Lord. There, my Lord, the court dealt with an urgent interdict application brought, as it turns out, by a learned friend, Mr. Mpofu, to stop the parliamentary process for the removal of the Public Protector. And he did so pending, like here, a Part B challenge to the new parliamentary rules that were going to govern that procedure, my Lord. Instructive, however, is how the court dealt with the request for urgent interim relief to protect someone that the court had already found to be constitutionally delinquent. When I say court, I mean the Constitutional Court, my Lord. At paragraph 127, you'll see what the court says. It says, the applicant has, in my view, failed to meet any of the requirements for interim relief. Even if she'd done so, I would have exercised my discretion in refusing such relief, given the severity of the charges that had been preferred against her and which had been based on trenchant findings by none other than the Constitutional Court with regard to her conduct, her honesty and her methodology of investigation, my Lord. In this case, similarly, we say, my Lord is bound by the damning findings made by the Constitutional Court in respect of Mr. Zuma's scandalous attempts to undermine and destroy the rule of law. Those findings grounded the very constitutional order that Mr. Zuma would now have this court interdict. This is not only impermissible, as we've already argued, my Lord. But even if it were not, even if he could ask this from my Lord by way of jurisdiction, my Lord should exercise his discretion against granting that order. Lord, let me say just two very short things in respect of Part B and standing. Part B, my Lord, there is a Criminal Procedure Act challenge inherent in Part B. And my Lord, in the debate with Mr. Nthatube, my Lord said, with respect correctly, but the Constitutional Court has already spoken on that. It has done so in Mamabolo and other cases. Absolutely, my Lord, but it's gone one step further, and that mustn't be forgotten. It has spoken, my Lord, on this very process, affirmed its constitutionality, and said that it will, under that process, commit Mr. Zuma to prison in its judgment of the 29th of June. It's already balanced all of these features of the criminal procedure process, and that it's civil contempt, and that there's a criminal sentence that's imposed. It looked at that in great detail, my Lord. We've looked at this in our heads, and we'll commend those passages to you. I know we don't have the time now, my Lord, but all we would say is that the Constitutional Court was very much alive to its own jurisprudence and to the very arguments that Mr. Mpofu wants to raise about the Criminal Procedure Act and its supposed unconstitutionality. So much so, my Lord, that there was a rigorous debate between the majority and the minority about this. And yet the Constitutional Court said that this process is constitutional, and that finding, my Lord, with respect to you, is binding. My Lord, finally, and very, very briefly, and only because we don't think that much can be said about this, but we just want to put the record straight on standing, my Lord. There was a suggestion that somehow the Helen Suzman Foundation, and unfortunately gratuitously was described as an uninvited busybody or an organization with a laptop. Well, with respect, my Lord, I think our learned friend and anybody else that's litigated in the courts knows very well what the Helen Suzman Foundation does, my Lord. But we are obviously here in the public interest. And we were cited, my Lord. Our learned friend said that his words, well, we were cited, he said, because in terms of Rule 42, you've got to cite interested parties. Well, absolutely, we were cited. He then attempted to suggest, my Lord, that somehow there were what he called primary parties and peripheral parties. Lord, I've never heard of such a distinction in our law. One is a party or not. And they cited us as a party in the form of the seventh respondent. They've dealt with our arguments. They've engaged with them. And for better or worse, my Lord. And the simple point is a party is a party. When you cite it, it gets to come to the party. So with respect, my Lord, we are a party, and we are very happy to have hopefully assisted, my Lord, in this context. My Lord, if there are any other questions or any other issues that I can assist with, my Lord, I'd be happy to, but those are our submissions.
Thank you very much. Thank you. Mpofu? Mr. Mpofu, are you still
Yes,
there? Yes,
yes.
Anything in reply?
Yes, of course, my Lord. My Lord, if I may just quickly dispose of my learned friend's last argument. None of them have answered the question, this very simple question, which is, if the constitutionally assigned bodies have decided to abide the decision of this court or not to oppose, as the case may be, because of what they call the current situation, and because the case is going to be heard next week in the Constitutional Court, then what business is it of the Commission on State Capture, Justice Zondo, and the Helen Suzman Foundation, which incidentally came to this party, as my learned friend describes it, on the basis that it agreed with the minority judgment that a coercive order must accompany the punitive order. In other words, exactly the point that we are raising, which they now say is hopeless, in Part B, namely that the unprecedented situation, according to Justice Khampepe, where a person is solely indicted, quote unquote, for jailing, should not take place. It is true that the majority did not accept that submission from the Helen Suzman Foundation. But if that was the basis upon which they acquired the status of a party, then it is very strange indeed that they abuse that same status to argue the exact opposite of that which granted them the status. As for the Commission of Inquiry, really, it is not clear on what basis, except, as I said, in pursuance of the acrimony that is obviously between those parties, why a Commission of Inquiry, which has a particular mandate given terms of reference, should busy itself with whether or not the police execute an order in KZN somewhere or not. It would be like a complainant in a criminal matter coming to a court to say no, on such and such a date, the arrest should be effected and not on such and such a date. I mean, where has that ever happened? The only reason that the Commission could ever conceivably be involved in these proceedings is merely, as I say, to ensure that the rights of the appellant are not exercised in front of the Constitutional Court or in front of any court for that matter, the fair trial rights, let alone his right to challenge the constitutionality of the conduct and the law under which he is threatened to be incarcerated. Well, my lord, you know, this court, if it seeks to effect the imprisonment of Mr. Zuma, it will have to climb many mountains indeed, because, my lord, there is no basis upon which the parties, they come here, my lord, they raise a jurisdictional challenge, and then they say, we have not brought any authority, and Mr. Du Plessis actually goes as far as there's no authority that he could find which deals with the situation where the order of a higher court is being challenged. Well, that should then be the end of it. If the people who have come to your lordship to say that that should not be done, and they have no authority to base that proposition whatsoever. I listened very carefully. Both Mr. Nguraitobi and Mr. Du Plessis have advanced no authority whatsoever for this proposition. So this proposition just comes from their heads that a court is precluded from exercising jurisdiction over an order of a higher court. That's all. The court must find that just because they say so, when there's no court that has made that pronouncement. Well, I have news for them, my lord. Jurisdiction doesn't work like that. The jurisdiction of the High Court is premised on the basis that you must show that the jurisdiction of the High Court has been ousted, not the other way around, that you must show that the jurisdiction of the High Court is excluded on some basis just because I say so, and then you sit down. It can't be. That is what is meant by inherent jurisdiction. In other words, as the section I read out to the court is very clear, the jurisdiction of the High Court on constitutional matters on any constitutional matter, unless if it is excluded. It's not the other way around. You don't say it's excluded because Mr. Nguraitobi, my learned friend, and Mr. Du Plessis say it is excluded. You must show a basis upon which it is excluded. So jurisdiction doesn't get excluded by the whims and wishful thinking of the other side. Where in this entire 2.5 hours that they've been speaking, my lord, where did they show your lordship the basis for the exclusion? Because that's the word they're looking for. for the exclusion of the jurisdiction of this court? The answer is nowhere. I was listening very carefully to understand where are they going to base the exclusion of this court's jurisdiction. When all the cases are saying that this court has got jurisdiction to regulate and to issue orders pendente lite, even if it cannot reach the main proceedings. In other words, whether it's in another province, whether it's overseas, and so on. So what is the difference between that proposition, my lord, and when the main proceedings are in the Constitutional Court, if I may ask? Because the exclusion of jurisdiction, for example, in labor matters, is based on Section 157 of the Labor Relations Act, which says that, let's say it's an unfair labor practice matter, then the exclusion of the High Court is excluded. Chirwa says that, Gaba says that, all those cases say that unless jurisdiction is excluded expressly, then it is the jurisdiction of the High Court is there. And your lordship will listen to everything that they've said, read their heads, and your lordship must ask yourself the question, where do they say that the jurisdiction is excluded? They just say they find it amazing or whatever, or they have not found a case which says the opposite. But they are the ones, it's not us who brought a jurisdictional challenge, my lord. So it is them who brought a jurisdictional challenge. So they must justify it to your lordship with the greatest respect. And I accept, my lord, that when we oppose their jurisdictional challenge, we ourselves have to show your lordship the basis of the jurisdiction. And I have shown your lordship ad nauseum the basis of the jurisdiction of this court. And unlike my learned friends, I have relied chapter and verse on the fact that this court has got jurisdiction over Part A, not Part B. Mr. Ngukaitobi is mistaken when he thinks we're only talking about Part B. Part A, the Section 172 basis for jurisdiction is based on Part A, because that's where the suspension order is. It's not based on Part B. The jurisdiction of this court to issue a suspension order is very clear from exactly what he read out from Section 172, which is this, my lord. When deciding a constitutional matter within its power, a court must declare any law or conduct inconsistent with the Constitution, may make an order that is just and equitable. And then Mr. Ngukaitobi goes to the words, a matter within its power. But that's a secular argument, because we are dealing here with jurisdiction. That's the very question we're dealing with. In other words, Mr. Ngukaitobi is quite right that the jurisdiction must pre-exist on the basis of another reason. But that is exactly what we have been at pains to explain to your lordship, that the jurisdiction pre-exists on the basis of territorial jurisdiction, which they don't challenge, that the jurisdiction exists on the basis of the fact that the act, as Pollack puts it, which is being prohibited, is to take place within the jurisdiction of your lordship. That the jurisdiction exists because of Section 172, that the jurisdiction exists because of the constitutional challenge to the Criminal Procedure Act. How much more pre-existing jurisdiction must be shown to this court in order to make it clear that it is within the ambit of Section 172? And Mr. Ngukaitobi did not challenge any of those bases. Instead, he goes he spent more than half an hour talking about something that we have not relied on. The cases of Oosthuizen and what have you have got absolutely nothing to do with my primary argument, my lord. Your lordship must please understand one thing, that we are not relying on this case for jurisdiction on section 173. We are saying that, so even if your lordship's interpretation or the one that your lordship put to me about the own processes was correct, that is not our basis for this jurisdiction, my lord. Our basis was explained to your lordship as starting from section 169 of the Constitution, which is the one I've already relied on, which says that any constitutional matter, except if that matter is only in the Constitutional Court, may decide. That the width of that section is sufficient without having to rely on section 173 to ask the rhetorical question which I asked in chief, where in section 167.4 is the jurisdiction of the exclusive jurisdiction of the Constitutional Court invoked, and the answer is nowhere. So it doesn't help for my learned friend, Mr. Nzukaitobi, to go on and attack an argument that is not being relied on, just because it is in his heads of argument. Because that's just, going ahead as planned, irrespective of what is in front of you. What the argument that he has to confront is the argument that he failed to confront of the jurisdiction over Part B, jurisdiction in 172, the territorial jurisdiction, and the jurisdiction that was that arises from the reading of the order itself. The fact that it is there's an assignment of the execution to the police. Now, my lord, let me just make one thing very clear. Our courts have said, and I'm now addressing specifically the issue of concurrent jurisdiction. Your lordship will know that in in our pleadings there is direct reliance on section 172 for the suspension order, and I won't go back to what to the distinction made by His Lordship Justice Jafta in the EFF versus Godani. My learned friend misquotes or misunderstands the judgment in EFF versus Godani. That judgment is authority for the exact proposition that we make, which is that a suspension order was granted in that matter against the implementation of the binding remedial action of the public protector. That binding effect, which was confirmed in the EFF1 case, which renders it maybe slightly below a court order, but binding effect nevertheless. And the basis of that, my lord, was the fact that the harm that would be done to Minister Godani if the order was implemented and he would then succeed, let's say win the case later, the review case, was obviously, according to the Constitutional Court, more overwhelming than any harm that the public protector might have suffered simply because the order was not being executed. That is the exact situation we're facing here, which is that the harm that the applicant will face if the order is executed now makes any harm, and in fact the harm on the other side is non-existent. So, as we always say, if you weigh anything against zero, it is the outcome will be that thing. So if the harm of arrest is weighed against no harm whatsoever to the respondents, then the sum total of that is that the suspension order must be granted on the very same basis that it was ordered in EFF versus Godani. So, my lord, the issue of concurrent in Gaba, the following was said, and it can never be clearer than that. Gaba is 2010, volume 1, SA 238, my lord, at paragraph 75. Jurisdiction is determined on the basis of the pleadings. Jurisdiction is determined on the basis of the pleadings. What do the pleadings tell this court in Part A, Section 72? What do they tell you in Part B, constitutional challenge? Where do those things lie exclusively? In this court? That is pre-existing jurisdiction, and therefore that is engaged. And it says, the problem that Mr. Ngugaitobi, my learned friend, tried to do was to conflate the jurisdictional challenge with the merits. That is not allowed, my lord. So you can't say you must deny the relief because there's an alternative remedy in the Constitutional Court which relates to the jurisdictional challenge. That's just mixing up two separate concepts. Because the issue of alternative remedy, I mean, if that was true, imagine that if that was the law, my lord, it would mean you will never get an interdict, for example, in the High Court relating to an employment law dispute. Because they will say, no, but you have an alternative remedy in the labor court. I mean, what is that? The jurisdictional challenge has to be looked at on its own merits. It can be the mere fact that there's another court which may entertain a challenge, then denies you. That's mixing up two completely different things. And this is what Justice Van der Westhuizen was saying in Gaba. Jurisdiction is determined on the basis of the pleadings and not the substantive merits of the case. That's what he said. And he says, if Mr. Gaba's case were heard by the High Court, he would have failed for not being able to make out a case for the relief he sought, namely the review and administrative decision. In the event of the court's jurisdiction being challenged at the outset in limine, like here, the applicant's pleadings are the determining factor. It can't be clearer than that, my lord. In the event of the court's jurisdiction being challenged at the outset in limine, the applicant's pleadings are the determining factor. They contain the legal basis of the claim under which the applicant has chosen to invoke the court's competence. And Mr. Ngugaitobi says that the applicant must be criticized for choosing one court over another when both have concurrent jurisdiction. But that's exactly what the Constitutional Court said, that it must be done on the basis of the claim under which the applicant has chosen to invoke the court's competence. While the pleadings, including in motion proceedings, not only the formal terminology of the notice of motion, but also the contents of the supporting affidavits, must be interpreted to establish what the legal basis of the applicant's claim is. Right? What is the legal basis of the applicant's claim? And I've already described it. It is not for the court to say that the facts asserted by the applicant would also sustain another claim cognizable only in another court. Right? Let me read that again. It is not for the court to say that the facts asserted by the applicant would sustain another claim cognizable only in another court. This is the Constitutional Court explaining the situation that is in front of your lordship. And yes, then, my lord, that of course is a double authority, because in paragraph 75, his lordship, Mr. Justice Van der Westhuizen, was also relying on Justice Langa in Chirwa, both Constitutional Court authorities, binding on this court at least. But another binding authority, my lord, is the case of Makanya versus University of Zululand. And if your lordship can go to It's 2010 bracket 1 SA 62. It's SCA, it's the judgment of His Lordship is Justice Nugent. And he says, my Lord, the original, at paragraph 23, the original power of the state to bring disputes to an end is assigned in this country to the high courts by the Constitution. And then he cites section 169, the one that I relied on for your Lordship. The original power of the state to bring disputes to an end is assigned in this court by the Constitution. And then it says, judicial power is the power both to uphold and to dismiss a claim. Let me just pause there. So it doesn't help to say that it's not part of the jurisdiction debate to say that the main claim you're going to win or lose. Jurisdiction means that you have a power to assert your claim and lose, but that court will still have jurisdiction if it's clear. In other words, it says it is sometimes overlooked that the dismissal of a claim is much an exercise of judicial power as the upholding of a claim. A court has no power to consider a claim, or rather, that has no power to consider a claim, has no power to do either, other than to dismiss the claim for want of jurisdiction. And it says, in general, the High Court thus exercise the original authority of the state to resolve all disputes of any kind that are capable of being resolved by resort to law, unless that authority has been assigned to another court. I mean, my Lord, it can never be clearer than that. The High Court has original authority of the state to resolve all disputes, all of any kind, unless that authority has been assigned to another court. And he says, when the High Court resolves a contractual claim, it exercises that original jurisdiction. When it considers a claim for enforcement of a constitutional right, like here, it exercises that original jurisdiction. So when the court considers a claim for the enforcement or execution, which is the same thing, of a constitutional right, it exercises that original. So too when it enforces a statutory right. And then a paragraph, I'll jump to paragraph 26. 25, it says, when a statute confers judicial power upon a special court, it will do so in one of two ways. It will either do so by conferring power to that court, excluding the ordinary power of the High Court, or it will do so by conferring on the special court without excluding the ordinary power of the High Court. In the latter case, the claim might be brought before either court. In other words, either that other court or the High Court. And then in the present context, the exclusive jurisdiction to enforce LRA rights has been assigned to the labor court forums. But in respect of the enforcement of both contractual and constitutional rights, the High Court retain their original jurisdiction assigned to them by the Constitution. And then he says, naturally, a claim that falls within the concurrent jurisdiction, which is the real point here. A claim that falls within the concurrent jurisdiction of both the High Court and the Special Court could not be brought in both courts. A litigant who did that would be confronted in one court by lis pendens, which is obvious, because if it had been brought in the High Court and the Constitutional Court, then lis pendens would apply. So in short, my Lord, unless the jurisdiction of this court is excluded by something which has not been said by anybody, then the jurisdiction of this court must exist. Then, my Lord, my learned friend, Mr. Ngatobi, makes another fundamental mistake when he says that the Constitutional Court deliberately did not exercise its mero motu powers to suspend the order. My Lord, there are two things here. which cannot be wished away. One, I have said that the Constitutional Court has decided, it used its mere motu powers, by the way, because this was not brought under Rule 12 of the Constitutional Court. It was brought under Rule 11. So the court, Rule 11, meaning it's the equivalent of Rule 6.5 in our courts, my lord. It was brought as an ordinary application, but the court used its mere motu power to expedite and treat it as an urgent application. As I said, that must mean something. But more importantly, my lord, the Constitutional Court did not do what my learned friend Mr. Ngcukaitobi says your lordship must infer by inferential reasoning, that because it did not suspend the order, therefore it meant that the order must be executed. Quite the contrary. The Constitutional Court was made aware of the application before your lordship. So the Constitutional Court knew that there are these proceedings for the execution of this order, and therefore surely, my lord, must have issued its order on the extreme understanding that this court, if there is a case for pendent relief, as happens every day, will grant that. That's number one. Number two, we've already said that the both orders are deliberately not opposed by the police, and the Constitutional Court, when it received the letter yesterday, at the very least, was aware that both its order and this one are abided by the constitutional authorities assigned with the power. Your lordship will find authority, or rather the support for that contention at paragraph 100 of the application to the Constitutional Court, which is at page 34 of the paginated papers. This is again for the open cards that the applicant played with both courts, so that each court should know. In your court, my lord, we attached the Concord applications, and then in that court, we said the following at paragraph 100. For the sake of completion and transparency, and although of no direct or immediate relevance to this application, I wish to disclose that I have given instructions to my legal representatives to launch parallel proceedings in the High Court aimed at inter alia challenging the constitutionality of the Criminal Procedure Act insofar as it fails or omits to cater for affording the normal fair trial rights to persons facing imprisonment in proceedings which are solely aimed at their imprisonment. To the extent necessary, this court will be appraised of any progress in that regard. In other words, my lord, when the Constitutional Court on Saturday issued its directions, it was fully aware that there is this particular challenge and there is interim relief which is being sought here. Inter alia on relief over which it has no jurisdiction. Right? Inter alia on relief for the challenging of the constitutionality of the Criminal Procedure Act, which has to come to the High Court. So the Constitutional Court was fully aware of this, and it is still fully aware. In fact, it has even been more appraised now by the Minister of Police and the other parties yesterday in the letter that was written to the Acting Chief Justice. It has been updated. So it is the exact opposite of what my learned friend Mr. Ngcukaitobi sought to argue. It is because the Constitutional Court expects your lordship to exercise his obvious jurisdiction over the unconstitutionality challenge and over the Part A issue, which is what we call what Mr. Ngubatobi, my learned friend, calls the pre-existing jurisdiction. That's the context in which the Constitutional Court actually gave the order. Otherwise, the Constitutional Court might have said, and Mr. Ngubatobi might have said that the case must be heard on Saturday or Sunday or whatever. But it knew that there is this challenge. Why? Because the applicant disclosed it for the very reason that that was exercised. And my learned friend, Mr. Ngubatobi, then went on to actually misrepresent the facts of what has actually happened, because he says that the applicant should have brought, I think his words were, should have brought his challenge within the 5-day term of the order, I think it's order number 4. But my lord, that's exactly what the applicant did. He brought that challenge within that 5 days. On Friday, it was day number 2 or day number 3. And the reason, my lord, he did that was so that both this court and the Constitutional Court would be aware that there are these 2 challenges, 2 separate challenges. He could not bring it after the Sunday. My learned friend is quite correct, after the first deadline. Why? Because then there are false accusations that he is in contempt of court would have been sustainable. But they cannot be sustained, my lord, with the greatest respect, when everybody knows that there is a pending court challenge. Your lordship knows that there's old law of what was called constructive contempt of court, in respect of which it was said that if you know, if there's a court case against me that says you may not execute this order, and I quickly go before the court sits to execute it, then I could be found under that law of constructive contempt. In other words, I've not breached a court order because there's no court order, but I've breached the authority of the court in that I know that tomorrow this matter is going to be heard by a court of law, and I quickly go and say, let me grab the motor car or whatever it is before the court can sit tomorrow. That is a form of constructive contempt. And that is what these parties are saying should be done. That the police should have said, oh, well, there is this court challenge, but let's quickly go before Tuesday, before Justice Mnguni can entertain this challenge. Let's quickly go and arrest the accused, so that we can then say, there was no court order, and preempt deliberately the court order. That's willful contempt of court, actually. And no self-respecting government agency would do that. In fact, that kind of conduct, my lord, was deprecated in the Piccoli case that I referred your lordship to. At paragraph 408, rather page 408 against the letter F, says, where there is a serious challenge to the validity of the purported exercise of public power. And let me pause there, my lord. I'm not putting the proposition any higher than the fact that the Constitutional Court has given these directions because, in its view, there is a serious challenge to the court order. I'm not saying that it means that there will be success. I mean, that would be ridiculous, because obviously the Constitutional Court cannot preempt, and nobody can preempt the result. But that recognizes that there's a serious challenge. And this is what the court says. Where there's a serious challenge to the validity of the purported exercise of public power, a state of uncertainty necessarily follows, which is where we are now. On the one hand, the action is treated as if it were valid until declared invalid, which is what our learned friend wants your court to declare. On the other hand, the practical consequences of the action may turn out to be invalid as well, which is exactly where we are. And here we're talking not just of ordinary exercise of public power, but the power of arrest, as I said. For that reason, the law requires of all concerned to respect the pending legal process and, as far as reasonably possible, to limit the practical consequences of the challenged action. Quote, in appropriate circumstances, an authority should halt its actions when it is aware that review proceedings are to be instituted against it. So it says, my lord, even if the police were just aware that proceedings were going to be instituted, it should halt its process of execution. How much more when it didn't know that it was going to be instituted? It actually was sitting in its hand with an application that is that has been brought. And it says failure to do so, in other words, on the part of the police and the president and the national commissioner. Failure to do so may render the official concerned liable for contempt of court. So how can it be, my lord, that these officials are expected to have exposed themselves to contempt of court on the basis of executing an order with the knowledge, not that the proceedings are going to be instituted, but that they have actually been? That would be the most irresponsible act of any government, indeed, my lord. In fact, if that had happened, then your lordship might have had to hear the application on Saturday or Sunday, because those officials would have been in clear contempt of court, despite the fact that your lordship would not have already granted any order. And that's what our learned friends say your lordship should authorize. You must authorize anarchy and contempt of court by the police to execute an order in the knowledge that it is being challenged in a court of law. And one may ask, my lord, what does the commission and the acting chief justice want from ex-president Zuma? They said he must be imprisoned because pending his review application, he did not approach a court to seek interim relief for the suspension of the warrant or of the summons to appear before the Zondo Commission. That's what they said. That's why we're here. Now, President Zuma does exactly that which they say he should be imprisoned for. He institutes proceedings in the Constitutional Court and approaches a court for interim relief, takes their advice, because they say that he must be imprisoned if he doesn't seek interim relief. And then he asks for the interim relief, and then they say he must be imprisoned for that now. So he must be imprisoned for failure to ask for interim relief pending the final setting aside of the judgment. But he must also be imprisoned for actually seeking interim relief for the suspension of an order pending the setting aside. So President Zuma, whatever he does in the eyes of the commission or the acting chief justice, he must just be imprisoned, even if he takes their advice, which he says, by the way, my lord, in his affidavit. I accept, because as I say, hindsight is a good teacher. He says, I accept that even though I was advised that the prospects were low, I should have asked for interim relief. And now he actually, to show that he means that statement, he does exactly that now. But no, your lordship must send him to jail for doing exactly that.
I can't send him to jail, Mr. Mpofu.
Well,
I can only dismiss his application. I just can't either dismiss or I can't send him to jail.
Well, my lord, again, that would be the impact. If your lordship, okay, let me put it this way. If your lordship washes his hands from his jurisdiction to exercise his jurisdiction over.
It's not an issue of washing, my hands. The issue is whether, let's say, it's a legal point which needs to be thoroughly
Yes.
Rest. Do I have powers to say to the Constitutional Court judges, your order should not be executed? That's an issue. That's a fundamental issue.
No, my lord.
It's not of washing one's hands.
Okay. No, my lord. You are not asked to say anything to the Constitutional Court judges with respect.
No, they've already said, they've already issued an order. They've already told us what, in terms of the order, should happen.
Yes.
Then I must. You want me to say what you are saying should happen as a Constitutional Court? I'm saying to you, that will not happen as a judge of the lower court.
Well, my lord, if I may ask, then the issue is, how is the jurisdiction of the court, of this court, ousted simply because one of the reliefs sought before your lordship, let's say there were 10 reliefs, and your lordship had jurisdiction over 9 of them. Then on what basis would your lordship then say, I'm not going to exercise my jurisdiction over this, even over these 9 causes of action? Because one of them, on some basis that has not been explained, has implications for a higher court. That, my lord, with the greatest respect, if there was any authority for the basis for this proposition, then I would sit down and rest. But on some basis over which there is no authority, your lordship should, with respect, not exercise his jurisdiction over causes of action that he would otherwise have jurisdiction over. That, my lord, with the greatest respect, would be literally the court just abdicating, with respect, its responsibility to exercise the jurisdiction, at least, as I say, over the 9 causes of action. Which, by the way, because the 10th one, which let's assume there was no law that says you can exercise jurisdiction even if the matter is going to happen in a foreign jurisdiction. Let's assume there were 9 causes of action, but the 10th one was in the USA. And then the court says, no, because your 10th cause of action is in the USA, I cannot exercise jurisdiction over the 9 that are here in KwaZulu-Natal, not even in KwaZulu-Natal, in Pietermaritzburg. These things that happened here outside of the court. I don't know the street name of that court, but issues that would have happened outside of literally outside the court. The court will not exercise its jurisdiction because one of the causes of action is in the USA. We now know that if it is jurisdiction pendente lite, even that would be wrong. It would be unlawful because the court has got the reach over that other, over that 10th cause of action. So it is that simple, with respect, my lord. Whether a court of law can say, no, I'm not going to exercise jurisdiction because it may also affect the concurrent jurisdiction of another court, whatever that court might be. And simply because that other court happens to be, let's say, the SCA. Yeah, let's say, forget the Constitutional Court. Let's say it was an order of the SCA, and which is a higher court, again, to your lordship. So on this logic, then I can bring 10 causes of action, but if one of them is based on an order of the SCA, then the other 9 causes of action over which there is jurisdiction must not be exercised by the court. Such a startling proposition, if it were true, I am quite sure there would be authority for it, and there is none whatsoever. And similarly, the constitutional, the SCA, on that logic, would have an appeal in front of it with 10 causes of action, and one of those in the Constitutional Court, and it would reject the whole case and not hear it because there's a 10th cause of action that is in the exclusive jurisdiction of the Constitutional Court. That has never happened, my lord. There are cases, as your lordship knows, for example, which might include the confirmation of a constitutionality, where the SCA would say whatever it says, but knowing full well that the final say on that matter is in the Constitutional Court. But it would never say, we don't have jurisdiction to pronounce on this because the final say is in the Constitutional Court. That would be denying a litigant of his Section 34 right to have a court of law determining his any dispute that is resolvable.
But here we're talking about a matter that is pending at the Constitutional Court. This matter is pending at that court.
Yes, my lord. I don't understand what that's why it's called pendente lite, my lord. It is because the matter is pending before that other court. That's why it's an interim interdict pendente lite. Otherwise, it would not be interim interdict pendente lite if there was no pendente lite. Means that litigation pending in another court. Exactly that, my lord. You might find interdicts for all sorts of reasons, but this one called interdict pendente lite, which is the one we're seeking here, is only available if there's pending litigation. It's not otherwise available. So that is exactly the reason why we're here, is because there is pending litigation in another court. And your lordship would not be interfering, as my learned friend Mr. Ngugaitobe incorrectly says, with the functioning of the Constitutional Court, even if we were relying on Section 173, which we are not, where he was incorrectly quoting us. Because that court has said that it will hear the matter, my lord. It would be one thing. Let's assume the Constitutional Court had not issued the directions on Saturday. Then your lordship might have, or these parties who don't want who want the applicant to be imprisoned, irrespective of the court proceedings, might have then come to your lordship and say, well, my lord, in fact, I know they would have, because that's what was being bandied about again in the media. They would have said, no, but the Constitutional Court is not even going to hear this. It's going to reject it on the papers. And so how can your lordship give an interdict pending something that may not even ever happen? But now we're in another world, my lord, where we know, your lordship knows, as a matter of fact, that on Monday that application is going to be heard. And your lordship, neither your lordship nor I know what the outcome of that application is going to be. The outcome of that application may well be, as it is said in the Piccoli case, that the order is set aside and that there is no arrest that must follow. That may be an outcome, unless if anybody, and I challenged again, my learned friends, none of them have said it to your lordship, unless if anybody knows the outcome of the case next Monday and can rule out the obvious possibility that the order may be set aside. Only on that basis can it be said that the applicant must be imprisoned no matter what. And as I say, my lord, that could have been arguable if the Constitutional Court had not issued the directions. How can your lordship literally ignore whatever legal effect of the fact that the Constitutional Court is going to hear this matter next week on an urgent basis? How? And it would be, my lord, really an egregious invasion of the rights of fair trial of the applicant for this court to say, well, irrespective of the fact that next week the order might be set aside, I'm going to refuse you an interim interdict pending that eventuality on the basis that I only have jurisdiction over two other causes of action, but not one of them. And my Lord, all that is being asked, therefore, is look at the other alternative, my Lord. Let's say that the Constitutional Court on Monday hears the case and sets aside the order on Monday or on Tuesday. Then your Lordship would have, for an order really of 6 days, to say, let us wait for the outcome of the hearing on next Monday. But the Lordship would effectively be saying, and let's not cut about, we can't say, no, it will be this or that. Your Lordship would effectively be saying, in that 6 days, the applicant must right to not to be detained without trial, which are enshrined in the Constitution, must be taken away from him. And his Section 35 rights which are in the Constitution must be taken away from him. And my Lord, there is nothing further from the truth than this idea that Part B, the Part B relief is, I think the word that was used, will not succeed because it was decided in Machabeng and Mamabulo and Faki.
Yes.
But Lord, that is an absolute misrepresentation of our law. In Faki, you will see that my learned friend, Mr. Ngugaitobi, quoted paragraph 26 and 27. The previous paragraphs, my Lord, say the exact opposite about what should happen. At 22, it says the decision to deal with statutory presumption reversal, but they undoubtedly entail where the state prosecutes an alleged contempt at common law for non-compliance with a civil order. The requisite element must be established beyond a reasonable doubt. In such a prosecution, the contemptor is plainly an accused person in terms of 35(3). Right? What does that tell us? It tells us two things: that where such punishment is needed, then the applicant is an accused person. And if he's an accused person, then he must be afforded his rights in terms of 35(3), which were denied in this particular case. What are those rights? They are the rights to a fair trial. And that's what this whole case is all about. So it doesn't help to jump to paragraph 26, where it says, and they quote where it says, I follow this path because the civil process for contempt is an oddity that is distinctive in this combination and so on. Without saying what is this path. The path that is being talked about is the path of 35(3) and affording the 35(3) rights to an accused. So Faki is the exact authority for the exact opposite proposition that you may not deny, which is exactly what Part B is all about. You may not deny the accused persons in these circumstances. And the words accused person, as your Lordship knows, at paragraph 22, are put in quotes because we know that it's a hybrid. But it says, as far as it's his punishment, he's an accused person, and therefore he's entitled to. And that is the fundamental mistake that the majority made, my Lord. Having correctly categorized these proceedings as hybrid, it then went to not to regard them in terms of Section 35 and 34, because hybrid means a combination of two things. So it means he's an accused, but he's also a litigant in terms of Section 34. But his rights were negated both in Section 34 and in 35. Machabeng, my Lord, which is the Constitutional Court, and to kill two birds with one stone, Machabeng also quotes Mamabulo. Machabeng is also the authority of the exact opposite. Just looking for the passage, my Lord. Machabeng, paragraph 81. is authority which supports the constitutional challenge that we are mounting in this court, my lord. It says the following. Remember, it talks about exactly what happened here. Summary committal without trial, basically. It says the procedure followed by the Free State High Court, or here you can say the Constitutional Court, clearly deprived Mr. Lipiana of the hallmarks of procedural fairness in terms of Section 35(3) of the Constitution. At the risk of repetition, he, and that's the same as President Zuma, he was arbitrarily deprived of his rights in terms of Section 12(1)(a) of the Constitution. Right? Same thing that we say has happened in our Part B, over which your Lordship has jurisdiction. The circumstances in Machabeng did not warrant the summary procedure. This procedure may be invoked in exceptional circumstances where there is pressing need for the firm or swift measures to preserve the integrity of the judicial process. This will also be the case where ordinary prosecution at the instance of the prosecuting authority is impossible or undesirable. Exactly what both the minority in Faki said should be done, which is to refer the matter to the NPA, and where the judgment in this case, which, by the way, even though it is a minority judgment, there's authority for the proposition that it is still binding to your Lordship in a lower court, and it cannot just be ignored. But be that as it may, it's and that would satisfy, of course, the idea that there is a prima facie right open to some doubt. I must concede that it's open to some doubt to the extent that it is a minority judgment. But that's exactly the requirement. That's why interim interdicts are given even when the primary right is open to some doubt. Anyway, it says but even then, in other words, even when it's referred to the prosecuting authorities where there'll be a fair trial, and to the extent possible, the contempt, that is President Zuma, must be according his or her fair trial rights. Otherwise, as this court cautioned in Mababulo, then it says, the alternative is constitutionally unacceptable. It is inherently inappropriate for a court of law, the constitutionally designated primary protector of personal rights and freedoms, to pursue such a course or conduct. It is inherently inappropriate for a court of law, the constitutionally designated primary protector of personal rights and freedoms, to pursue such a course or conduct. And that's all that Part B is all about. It is to assert those very powerful pronouncements of our Constitutional Court, that a person, insofar as he is an accused, quote unquote, in punitive proceedings, must be afforded fair trial rights and the right not to be detained without trial. And to say that those considerations are not, or for this court actually to preempt that challenge and say, no, the Section 12 and Section 35 rights will never be asserted by the Constitutional Court, or it will never be said that the Criminal Procedure Act must cater specifically for this unprecedented situation. Where would this court really get the power to say such a thing? To say that the Section 12 rights and Section 35 rights will never be catered for in the Criminal Procedure Act. And my lord, the most interesting is that Mr. Duplessis says that when I say that the court order, they both say that Mr. Toby says actually the powers were not delegated to the police by the Constitutional Court, they were mandated. Well, I don't know what the difference between the two is. delegation and mandate and giving somebody a mandate is exactly the same thing. But the point I was simply making, my lord, is that the whatever English word you use, mandated, delegated, assigned, given, referred, whatever, it is that your lordship has in front of you the type of order that was referred to in Saratoga, where the Constitutional Court has not arrogated to itself the power to execute that order. It is that simple. It is the type B order where that execution has been given to somebody else. Therefore, the court has got jurisdiction over that somebody else. That's also a very simple proposition. And nobody can put it better than this book called Constitutional Litigation, which is written by my learned friend, Mr. Du Plessis, where he says at paragraph, at page 156, this situation, in other words, where the court takes over the power for execution, is distinct from cases such as Zondi, residents of Slovo, in which the court, quote, made just and equitable orders that made it clear that the court itself, in other words, the Constitutional Court, chose to regulate and oversee the execution. That's what my learned friend, Mr. Du Plessis, wrote in his book. And then he says, Froneman J. held that this was not the case in Blue Moonlight, as there was no indication in the order of any continued oversight by the Constitutional Court, exactly as it is here. There's no indication in the order of any continued oversight by the Constitutional Court. It's the contrary that is shown in the order, that the police and the station commander and such people must execute the order. And then he says, Mr. Du Plessis and others, in his book, in order to approach the Constitutional Court to enforce and vary an order, litigants must find an indication in the Constitutional Court order that it intended to retain supervisory authority. Absent such an indication, applications to enforce, and he says in brackets, and a related application, such as the one we have in front of you, if necessary, vary an order following a Constitutional Court decision will be required to be brought in the High Court. So this is what this authority, based on the authorities that I've cited, he says that absent an indication that the court would retain the power, that any order or related application of following a Constitutional Court decision. That's exactly what your lordship has been asking me. Where if it's a Constitutional Court decision, am I disempowered? Here it says, if it's a Constitutional Court decision, that person will be required, it will be required to be brought in the High Court. It can never be more explicit, my lord, that it is, according to the authorities, competent for this court to revisit and order a decision of the Constitutional Court in the High Court, absent an indication in that order that it was to be exclusively executed by the Constitutional Court.
How could the Constitutional Court have done that?
Yes.
With the order itself, how can it do that?
It does it in many ways, my lord, as it did in Moonlight. The cases that Mr. Du Plessis and the others were distinguished.
Because that's yeah. I mean, okay. We can carry on.
Okay, no. I need to understand. Your lordship saying the Constitutional Court can never make it clear.
No, I'm saying, how can they execute? You want them to go and arrest and make the arrest. It's not clear to me the basis of that proposition. That's why I'm asking you that.
No,
how can you, in this situation?
No, my lord. No, with the greatest respect, my lord, let's forget this situation. I'm telling your lordship principles of law.
I understand the principles of law.
Yes, the principle.
Yeah.
I'm sorry, my lord. The principle is simple, my lord. Unless a court order in front of you
Yes.
of the kind, there are two types of court orders. Let's call it type A. Type A is where the order is executable by the Constitutional Court.
Yes.
Type B is where the order is executable by someone else, right? We don't have to go to the reason why that someone else must execute it. It might be the reason that your lordship is saying that it is exactly because in that particular situation, it's an arrest or a licensing officer or whatever. But the point is, does your lordship has type A or a type B order in front of you? For whatever reason, if this authority says, if you have a type B order, and I dare say, my lord, you have a type B order in front of you, which is executable by somebody else, not the constitutional order. And it says a person who wants to bring an application in relation to that type B order must go to the High Court. If your lordship can then say, well, I have a type B order because of ABCD. Well, that's exactly why the Constitutional Court issued a type B order. So that reasoning is simply explaining why you have a type B order in front of you. It doesn't make it a type A order. It explains the reason why the Constitutional Court, in its wisdom, chose to make a type B order. Whereas in cases such as all pay, your lordship says, how would the Constitutional Court do that? In all pay, for example, your lordship knows that in the order of the SASA, the case that dealt with the old age pensions, the court retained the supervisory order to itself. And it was not, oh, well, there's a minister. How can the court be supervising every day, every 20 days, the court order? No, the court used its discretion to say, in this case, unlike in the case of Saratoga, unlike in the case of Zuma versus of the State Capture Commission versus Zuma, in this case, we will retain the supervisory order. Unless if your lordship is saying the court could never, under any circumstances, have said, we want to supervise because this is a case that is unprecedented and against the authority of the Constitutional Court, we can never actually say that in 10 days' time, so-and-so must report here to this court. In 15 days' time, so-and-so must report to this court. What would prevent the Constitutional Court from doing that, my lord? Nothing. It chose deliberately not to do so, but to refer the execution to somebody else. Remember, my lord, that is the basis upon which the jurisdiction of the Constitutional Court was sought. It was said because this is a violation of the court of the Constitutional Court's own order. So the Constitutional Court could have said, well, because this is a violation of our own order, we're going to supervise its implementation. I don't understand why or at least what would have stopped the Constitutional Court if it had wanted to do so, to put that kind of order. Even if it said, for example, that the police must report to it, to the Constitutional Court, then it would be what your lordship calls a structural interdict, but it would be an interdict that is supervised by the Constitutional Court. It is undeniable that this is not that type of order, but this is an order for which is referred to somebody else. Then, my lord, finally, we referred your lordship to the case in De Beer. Ironically, my lord, this case was decided. This case was decided on the 1st of July Just looking for my copy, my lord. Oh, yes. Your Lordship, talking about binding decisions, will remember that the order in this case was granted on the 29th of June.
Yes.
2 days later, my lord, on the 1st of July, last week, on Thursday, the SCA was faced with a situation of the most egregious form of contempt. And the Lordship will find reference to that case at paragraph 47 of our heads. Minister of Cooperative Governance of Cocta versus De Beer and another.
Yes.
Yes, my lord. And again, let me tell your Lordship where I'm going with this. It is the issue of how important it is to preserve the trial rights, the fair trial rights of an accused person, irrespective. My learned friends both started by saying they're not going to talk about the merits of the case, and they spent half of their time doing exactly that, saying that he did this, he breached the order 6 times or whatever. But your Lordship had already indicated that those are the matters that will be determined by the Constitutional Court next week. So your Lordship cannot take those into account, but I'm putting this to your Lordship as an example of how a court such as this one and how the SCA conducted such proceedings. Here it says, your Lordship will see that paragraph 1 quoted in our heads says the email dated 17th instead received by the Chief Registrar of the SCA, Ms. van der Merwe, which carried your answer to our letter refers. This is what Mr. De Beer or whoever it is. At paragraph 2, my lord, it says, after careful consideration of your official response, he says this to the SCA, the writer has decided to herewith inform you that the entire Supreme Court of Appeal may stick its fictitious apology to us in its blank, blank, blank.
Yes, I've read that case.
Yes, on the last week, Thursday, my lord. Yes. Now, with that kind of, I mean, if ever there was contempt of court, here's somebody like President Zuma who says, when there is this problem, I'm turning to the courts. I'm coming back to the courts. I'm going to the Constitutional Court. I'm going to Justice Mnguni to get relief. I'm explaining myself as to why I did not oppose the first application. But let's assume I was wrong in not opposing it. Should I be sent to jail simply because I accepted that the chances, like all litigants do, litigants may say, I will oppose this, I will not oppose this on a daily basis, and they may be right or wrong, but they're never sent to jail without a trial for that.
Yes, but that's how this case that we're dealing with is distinguishable from the case that we've quoted.
In which direction, Malak? That's exactly, it's distinguishable, but it's worse. That's what I'm saying.
Oh,
it's worse because somebody insulted and did not merely fail to attend court proceedings, but he insulted. I mean, I can't even read what he said about the court in public.
Yes, what I'm saying to you, in respect of the matter that we're busy with,
yes,
there were some opportunities that were given to Mr. Zuma. That's in this instance, that statement was made to the SCA, and they dealt with the matter differently. But he was given an opportunity. You must remember that was a case of the first instance. He was given a number of opportunities to come and explain. So,
yes.
In that context, this case is trying to rely on is from this one. But so, I'm not going to give you the merits of the case, and in any event, yeah.
Okay. Let me try and maybe explain. So your Lordship is saying that the situation of not opposing a matter which will be dealt with next week and maybe excused or not excused next week in the constitutional.
I'm not going to try and entangle myself on the merits of the case that is coming up on Monday. That's what I said. I don't intend to do so even now. Yeah. I'm just saying that this case that you have referred me to is distinct from the case that we are busy with.
Yes, my Lord. No, I agree. Yes, my Lord, I agree. When we refer to a case, we'll never find a case that has the same facts. That will never happen. Well, I'm agreeing with your Lordship that the facts of this case are distinguishable. Yeah. The only thing I seek to persuade your Lordship in is that this case are worse, 100 times worse than this situation which might be excused next week or may not be excused. What excuse could possibly there be, my Lord, for saying this to the Supreme Court of Appeal under the sun? For insulting the registrar and the court itself. In which world would anybody be able to say, no, but next week I might be able to give a satisfactory explanation of that? It will never happen. All I'm saying is that even in those egregious circumstances, my Lord, the SCA last Thursday decided not to imprison the person, but to refer the matter to the National Prosecuting Authority. That's really the only point I want to make to your Lordship. Why did they do that? Against the most serious, I'm not sure if your Lordship has read the actual part that I did not read.
Yes, I've read it.
Yeah, against the most serious provocation, that court still respected the fair trial rights of that person and referred the matter to the NPA. Why? So that he may have his day in court, and maybe or maybe not, he may be able to say to that court, I was taking some medication or whatever, and by the way, I'm 80 years old, and by the way, I have an ailment, and I will have my doctors giving you evidence, and so on and so on. In which case, that process might actually come up with a sentence that says this person was not responsible even for this kind of action, or was responsible but should not be sent to detention without a trial, or whatever. That is the only reason the SCA referred the matter to the NPA, so that he may exercise his fair trial rights. Now, all I'm saying to your Lordship is, if that can be done to someone who has almost, it's just as good as taking up a gun and shooting it in a court or whatever, then how much more for somebody else whose only sin is that he assessed a case wrongly and felt and thought that it would be dismissed and was wrong, and agrees with the court now that that assessment was wrong. How can that be a worse crime than this? That to such an extent that you must not pass begin, you must not do anything, you just go straight to jail, without going to any court. And that, with the greatest respect, my Lord, cannot be our law. And so, my Lord, any argument from my learned friend, Mr. Ngubatobi, that says this court must ignore its jurisdiction over Part B, for example, is wrong. And one may ask the following rhetorical questions. Which court has jurisdiction to hear a suspension order against the execution of a warrant of arrest by the police? The answer is that it is this court. Which court, according to the authority in Mr. Du Plessis' book, has got the authority to hear the challenge of a related application in respect of a constitutional court decision? The answer is that it is the High Court. Which court has got the exclusive jurisdiction to entertain a constitutional challenge to this Criminal Procedure Act? The answer is that it is this court. Which court has got the jurisdiction over the territorial jurisdiction over the persons who must execute this order? The answer is that it is the High Court. And therefore, Your Lordship will be hard-pressed to find that this is not a matter within its jurisdiction, as it is said in Section 172. It is. It's just a matter that is within its jurisdiction. And therefore, the court has no option but to exercise that jurisdiction. And it was in that context that I was talking about the washing of hands, my lord. The court cannot run away from the jurisdiction that has been conferred upon it by the Constitution merely because one of the orders is in the Constitutional Court. And my lord, yes. Well, Mr. Nkokaitobi actually said this. It does not matter where Part B lies. How can it not matter, my lord, where Part B lies, when you are being asked to grant an interdict pending that very same Part B? In other words, even if we were saying in Part B, Your Lordship must do something which is completely impossible. In other words, saying Your Lordship must, in Part B, you'll be hearing a road accident that happened in Cape Town, where Your Lordship clearly would not have jurisdiction. It doesn't matter. Your Lordship would still grant Part A. I mean, where does that come from? Surely it matters where Part B lies. And where Part B lies is within your province, my lord, and within your jurisdiction. And the idea, my lord, that somebody must be arrested and put to jail is completely against all authority about what the situation that, I'm sorry, my lord, I just wanted to refer Your Lordship, I'll just refer Your Lordship to paragraph 34 of a case called Els versus Weideman, 2011 bracket 2 SA 126. Says SCA judgment, judgment of His Lordship is a Justice Hare, Hehera. And he says, I do not agree that because contempt proceedings are a continuation of an already instituted proceedings, or, quote, no more than a step in the execution of the judgment must be enforced in the court which granted the original order. I know it's late, my lord, but I'm going to read it again.
Yeah.
That no more than a step in the execution, that the judgment must be enforced in the court which granted the original order. In other words, in the Constitutional Court. Says there's no authority for that proposition. And says when a party leaves a high court with an order in his favor, not obtained ex parte, those proceedings have been effectually completed, subject to appeal, or in the case of an interim order, its confirmation. So you could say here, subject to the rescission application. A subsequent breach of the order or willful disobedience to its terms outside the jurisdiction of the court gives rise to a right in the holder to take steps to enforce the order wherever in South Africa he may find the defendant. Wherever in South Africa, and that includes Nkandla, he may find the defendant. To hold otherwise would negate the statutorily created countrywide enforcement of judgments. Should the court approached by the complainant decide that because of reasons peculiar to the case before it, as this court is saying, the issue of contempt would be by the court which made the order. It might decide to exercise the powers to transfer the case to that court. So even if the court, for some reason, were to say that the order would conveniently be decided, that particular order, by the court which made the order, in this case, the Constitutional Court, it might decide to exercise its power to transfer the case to that court. What does that mean? It means the paradox of jurisdiction cannot, in other words, the court cannot dismiss an application that it says it has no jurisdiction over. Because by doing that, it will be exercising jurisdiction. What the court will do if, and again, it goes with these cases of the labor court and so on, it would then be to say, if let's say it was the Cape Town court for some reason, and it says because the contempt order was granted in another court, then I'm transferring it back to Cape Town. That's what the court will do. But the most important submission, my lord, and this is my final submission, that comes out of that paragraph 34, is that there is no qualification which is being sought to be introduced to your lordship artificially here, that the jurisdiction to exercise, if it comes from another court, it doesn't say from another court of equal jurisdiction or another court of inferior jurisdiction or another court of superior jurisdiction. It simply says any order coming from another court, this court has jurisdiction to exercise over it, where it came from anywhere in South Africa. And Braamfontein is somewhere in South Africa. So even this order that came from anywhere in South Africa from Braamfontein, this court has got jurisdiction to exercise for all the reasons that have been mentioned, my lord. The alternative to that is the most fundamental invasion of human rights that can ever be imagined in a case that deals with an arrest of a person over a matter that is going to be heard in 6 days' time by the highest court in the land. Because your lordship, directly or indirectly, will be preempting and prejudging the outcome of the case next Monday. Whichever way you look at it, your lordship will be saying, no, you must wait for your outcome in jail. And if that is not prejudging the outcome of what is going to happen in next Monday, then nothing ever will be. Because by that act alone, your lordship will be saying the exercise of the orders under section 3 and 4 and 5, 4, 5 and 6 of this court order must be immediately executed against the wishes of the people to whom the court has assigned those powers or referred them or whatever. When they say in their best judgment of the situation, those orders must await the outcome of the case on Monday. Your lordship will say, no, 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 you're wrong. Whatever, let's just have another Marikana. Let's have whatever might happen. Simply because this was an order of a higher court and with no authority being cited, I am tying my hands and I will not be able to prevent that which the police and the president and everyone else seek to prevent. For one reason and one reason only, because this is a higher court. There's no authority for the proposition, but I just don't feel that I should do it. And my lord, I'm told to refer your lordship to paragraph 119. I won't go there. 119 of the De Beer case, which says that the absence of interference would only be if there were exceptional circumstances. And here we say the exceptional circumstances go the opposite way. That's what the police say, there are exceptional circumstances. And incidentally, that's what the majority judgment says as well. It says there are exceptional circumstances in this particular case. And my Lord, let me put one thing to bed. There is this thing that goes around to say this judgment shows that all are equal before the law. The judgment shows the exact opposite. If all were equal before the law, then President Zuma, my Lord, would not be the first person in this country to face detention without trial. Simply because he's a former president, simply because, as it was cited in the majority judgment, because he's a former president and because he's what was called a constitutional being. So it means there will be no other case ever that would ever mirror this. This is just Zuma law, because there will never again be an 80-year-old former head of state who has. Your Lordship was talking about facts.
But you can put those arguments before the CC.
No, my Lord. They are relevant for this case because it shows you the amount of exceptionality. Remember, I'm addressing the simple question of exceptional circumstances. I'm saying the exceptional circumstances here are that your Lordship will be sending someone in circumstances which have never happened. That may, except I thought exceptional circumstances means exactly that. That is something that has never happened, number one, and is unlikely to happen again. That's really the only point I'm making. That's so exceptional that it has never happened in the past, according to Campempe ADCJ, but it will never happen again in the future either, because those circumstances will never, if that is not exceptional, then nothing ever will be exceptional. My Lord, therefore, if your Lordship was correct in that this matter turns on jurisdiction, then, my Lord, there is no denying that this court has jurisdiction. There's no. Let's assume there was no constitutional court order for a minute. On which basis would this court say it has no jurisdiction over this case? When Part A says it's Section 172 and Part B says it's constitutionality of the Criminal Procedure Act, when the respondent resides near the court's jurisdiction, when all the things that have been said here, on what basis? Assume for a minute, my Lord, there was no order of the Constitutional Court. The Lordship will have to ask yourself if this would be a case in which your Lordship would say this court does not have jurisdiction. If your Lordship can answer that question in the affirmative and say, absent the Constitutional Court order, this court would not have jurisdiction, then your Lordship must, of course, dismiss the application. But if your Lordship, as we employ your Lordship to find on all these bases, finds that this court has jurisdiction on all these other grounds, then your Lordship has no option, quite frankly, and no, in terms of 172(1)(a), the Constitutional Court, by the way, will also have no option because it uses the word must. And your Lordship has to postulate that the Constitutional Court must, if it finds on any basis, even 1%, that its order invaded any one right of the applicant, without even applying a Section 36 justification, as was done in Mababulo. If it finds that even 1% of any right, choose whichever one you like, dignity, detention, Section 35, privacy, if 1% of any right will be found to have been violated or limited without a Section 36 justification, then the declaration of unconstitutionality must be made. It's not optional. And if the declaration of unconstitutionality must be made, then we're back to section 172(1)(b), where the consequential relief must obviously be that you cannot imprison a person when their rights are being abrogated. 1%, that's the test your lordship has. 1% of any of the 5 rights or 6 rights that we are talking about will be enough, because it has been said that limitation in constitutional language is synonymous to infringement. So if you limit a right, even if it's the right of appeal, my lord, simply the right not to present mitigation before you are convicted, just take that one. That's the easiest right that was limited. We know that everyone is given a right to argue mitigation only after conviction, but this particular person was given the mitigation right 3 months before conviction. If that is not a limitation of a right, my lord, nothing ever will be, because the mitigating circumstances that were existing 2 months, 3 months ago are not the same as now. There's now level 4 COVID-19, for example, and that time there was level, whatever level it was. And so by giving somebody mitigation opportunity long before the conviction, you are limiting their right to Section 35. If your lordship needs to find just that, the 1% test as in RAF matters, that may just be a limitation. And it's common cause, this is what I'm talking about, my lord. It's not a pipe dream that the mitigation was granted long before, unlike any other accused person. All the people in jail today, my lord, were given their mitigation rights after conviction, all of them, from Messina to the Cape, all of them, except former President Jacob Zuma. He'll be the only person who will be in jail without having been given his mitigation rights before conviction. And if that is not exceptional again, then again, nothing ever will be. On those bases, my lord, and as I say, your lordship, we can be here all over. I can go through all the rights and show your lordship that 1 day in detention is also a limitation of the rights and so on. But your lordship gets the drift that it's on the 1% test. Then the minority will have been correct that at the very least, Section 36 application should have been made. And let's assume, my lord, that that's the only omission that the majority made, was not to apply this to a Section 36 right. Then Rule 42 says if there's an omission which amounts to like that, then you must rescind the judgment and set it aside. And therefore, the case for rescission would be 100% guaranteed, merely on that limited basis that there was an omission to apply a Section 36 limitation to any rights. So, my lord, with the greatest respect, there's nothing that stands between this court and granting the order sought. At least nothing that has been presented to your lordship by my learned friends, as the court pleases. My lord, as far as costs are concerned, our submission was that costs should follow the result. But if your lordship finds that because of the known attitude of the law enforcement agencies that this order must await next Monday, and these other parties nevertheless forged ahead to come to this court and make a non-existent case, then your lordship will leave it in your lordship's hands to indicate its appropriate opprobrium, particularly when they did so armed with absolutely zilch, nothing in their hands, no authority to say to your lordship on what basis your lordship does not have jurisdiction. Nothing. As the court pleases.
Thank you. We'll hand down the judgment on Friday at 11:30. Judgment is reserved. Thank you.
As the court pleases, my lord. We are indebted to your lordship.